This is Newsroom. I'm Eben Janssen with Rene West and Kendall Machamate here today. Yes, this is the Newsroom team. We're broadcasting live from our studios here in Auckland Park to the rest of the African continent. Don't forget, between 9 and 12, you can also watch us on YouTube through our streaming facility, or you can watch us on demand a little bit later. Just put the show and the date in, and you'll get today's show. Now, yesterday, it was a rather gut-wrenching day in the court, North Gauteng High Court, that is, where Barry Steenkamp, Reva's father, he asked the question of the day to you. And we ask you, should Reva Steenkamp's murder pictures be made public? That's the question. He said he thought so that people could see the suffering that his daughter went through before she passed on. It was a gut-wrenching day in the High Court. We'll be back there shortly, but first, let's go get the morning's news.
All arguments for mitigation and aggravation in the Oscar Pistorius sentencing proceedings must be completed today. Government is pulling all the stops to commemorate the 40th anniversary of the 1976 student uprising. And US President Barack Obama has warned that the policy of Republican presidential presumptive nominee Donald Trump to bar Muslims from entering the US is dangerous. Let's take a look at what's coming up in your sports news with Kendall Machamate. A very good morning to you, Eben, and to Kendall.
Good morning. Good morning, Renee. Good morning, Eben. Quite a lot happening on the sports front as well as in court, we know. Good morning to you at home. This is what we've got for you in the sports today. Mohsin Etugrad pens a 3-year deal with the London Pirates Football Club to take over from Tinkler as head coach.
Goodmanson. Oh, it's a golden opportunity, and it's one which Iceland have taken.
Euro debutants Iceland outshine Ronaldo and Portugal as they claim an historic draw with their more fancied opponents.
They've got world-class players all around, but we're just going to have to top that and have a better team performance.
Captain Naby de Villiers calls for a much improved night. All this and more we've got for you in the sports bulletin. Be sure to stick around for all of it. But for now, it's back to the main desk for the news.
Thank you very much, Kendall. President Jacob Zuma says African leaders are worried about conflicts in some parts of the continent. He was speaking at the end of the 6th International Conference on the Great Lakes region.
Standing alongside leaders of the Great Lakes, they are here to seek permanent peace to the strife-torn area. Though not a member, South Africa's participation is always valued.
I think it indicates the confidence that countries in the continent have to South Africa. And secondly, the role that South Africa is playing in the continent. Because as you would realize, whenever this conference meets, it discusses the problems that are of challenges to the Great Lakes in particular. And South Africa has played a role there, still playing a role. So in a sense, much as it is not a member, but it has been playing a role, particularly in the DRC, we still play a role up to this time. Ever since, particularly President Dos Santos became the chair, he has been consistently inviting South Africa to be part of, to allow that kind of interaction, and also that they will in a way affect South Africa there.
And the president is clear that the continent is not happy about sporadic incidents of instability in certain parts of Africa.
We are worried, and I think that's part of the reason such summits are called, to say, where are we? As I was saying today, we're discussing South Sudan, because it's important to know that something's being done, and South Sudan is shaping up. And that's why the president of South Sudan was not here, because he's busy dealing with the issues of we are also worried that much as there's been elections, it's a huge country. and there are rebels that have been roaming all the time. There is a new phenomenon between DRC, Uganda, of these extremists who are coming there, who are believing that if you're not a Muslim, you must be killed. It's a new phenomenon. How do we deal with that kind of an issue? It comes on top of some issues that are taking place there, because, for an example, the disarming of the rebels there, and some rebels must go back to their country. Those are issues that are worrying us. But they are not at the level at which they were before, where it was difficult to deal with. I think the existence of MONUC in the form in which it is, it has helped a great deal, where South Africa plays a role for those rebels just to run amok there. I think they know if they did so, they will meet some kind of big challenge.
All eyes will be on the African Union Summit in Kigali, Rwanda next month. Progress reports on various aspects of the continent will be presented. From SABC News, Luanda, Angola.
Deputy President Cyril Ramaphosa has urged alliance partners to rally behind the list of councillors in the run-up to the local government elections. Ramaphosa was delivering a memorial lecture on the life and times of the first president of COSATU, Elijah Barai, at Community House in Salt River last night.
The ANC Deputy President addressed this gathering to commemorate the life of COSATU's first president, Elijah Barai.
These days, comrades, you have to search very high and low to find leaders who commit themselves to principle, leaders who are deeply immersed in the values of the organizations of our people. Sometimes you can search and not find them very easily.
Ramaphosa says disgruntled party members who have been protesting over the list process must make peace that they are closed out.
If you've been left out, accept that it is closed, live to fight another day. Let us move on with the elections with those comrades who've been identified.
However, Ramaphosa says if violations are found in investigations, the Dlamini Zuma Commission recommendations will be implemented to the removal of irregularly nominated candidates. Meanwhile, the Deputy President also touched on the state of the tripartite alliance. Ramaphosa has called on the continued unity in the tripartite alliance and says only a strong alliance can secure the future of the country. Bulelani Philip, SABC News, Cape Town.
The Constitutional Court judgment regarding the IEC's voter roll has been widely welcomed by the Independent Electoral Commission, government and political parties. The court ruled that the IEC's failure to record all available voter addresses on the voters' roll is inconsistent with the rule of law obligations and is invalid. It has, however, suspended the invalid order, giving the IEC until June 2018 to furnish addresses for the voters' roll. However, in the case of Tlokwe, discrepancies must be corrected in time for the August elections. The court found that the municipal elections could not be postponed. The IEC unsuccessfully sought to appeal an electoral court ruling in February, which found that the Commission failed to ensure that the voters' roll issued to candidates had addresses. All arguments in the Oscar Pistorius sentence hearing must be completed today. Pistorius is being sentenced for the murder of his 2013. Yesterday's testimony by Barry Steenkamp brought many to tears.
Every day of my life, morning, noon, at night, early hours of the morning, I think of her all the time.
A shattered father, 3 years after his daughter was murdered. Barry Steenkamp grappling to come to terms with her death.
I don't wish that on any human being. Finding out what happened, it devastated us. I ended up having a stroke, and so many things since then have happened where I've gone to doctors and to surgeons, which I still have to go in for my heart and everything like that. I just don't wish that.
Even inflicted pain on himself to deal with the grief.
At times, I thought with the pain that Reva went through, I used to just, I don't know whether I was going mental or whatever, but I used to take my fist the walls with my knuckles, my injection from my diabetes. I used to take my stomach and my arms to see if I could feel the same type of pain.
And this was his only escape. And now, Barry Steenkamp wants justice.
Oscar has to pay for what he did. He has to pay for it.
An emotionally charged day. While the Steenkamp say they're far from finding closure, Barry Steenkamp says he's willing to meet now, while the state has indicated it will call another emotional witness who was close to Reva Steenkamp. Griselda Lewis, SABC News, at the North Gauteng High Court.
That is your top news for now, but let's go over to Eben, who has more on this.
Yeah, thank you very much, Renee. It's been an emotional day. I just saw Oscar go into the courtside there. Griselda Lewis is actually on the pavement today, a little bit closer to the action. Let's go to Griselda there. Good morning to you, Griselda. I just saw Oscar walk past you, behind you there, with a man in full military regalia, military uniform. What's that all about?
Well, you know, a very high police contingent or even security contingent. Well, the one this morning certainly was very reduced. Oscar Pistorius usually arrives in a vehicle here, but we saw him walk from the direction here behind me into the court this morning. But obviously, since the beginning of this trial, we saw to quite a lot of media that we saw here. So essentially what we're expecting to happen in this court here this morning is for the state to call another witness, an emotional witness as described by the state prosecutor there, Gerinel, where he said that the person who will testify today is quite emotional. So a lot of speculation at this point here, stating that perhaps the person that might be called might be someone who's extremely close to Reva Steenkamp. And certainly this is what we're seeing with the state. What they're basing their pre-sentencing arguments on at this point is that they want to show the impact that Reva Steenkamp's family, Reva Steenkamp's death has had on family and friends. And essentially, that's what they're basing their pre-sentencing arguments on. We saw yesterday, of course, and a very emotional father of Reva Steenkamp describing how his family has been broken by her death, saying several years later they're still unable to get through the pain and grief that has happened to them, and essentially saying that lost everything. Also mentioning that even after Reva's death, what essentially transpired is that the family had also been in such grave financial difficulty that they'd even lost their home, and said that even though Reva Steenkamp's mother, June, is someone who is consistently stone-faced, she's been described as that, hardly showing any emotion, but many saying, of course, that Barry Steenkamp essentially saying that he, during the course of the evening, is able to see June Steenkamp's grief, and often witnesses her crying and speaking to Reva Steenkamp as if she is there. So really quite grueling testimony that we saw inside this court here yesterday. We're expecting quite a lot of that here this morning. We're expecting really to wrap up proceedings here today, but a question defense will call another witness. They did indicate that they'd be waiting to see who the state will call and would basically base a decision on that, on whether they will call another witness. But really, what the state is essentially trying to do here is to show that Reeva Steenkamp's death, you saw the testimony that took place inside this court over the past couple of hours, relating to Professor Scholes, who had indicated that Oscar Pistorius was a broken man. So what the state is doing here at this point is to show that Reeva Steenkamp's death has had quite an immense effect on her family, both emotionally and financially, and essentially saying to this court that it has no choice but to sentence Oscar Pistorius to 15 years imprisonment. That's what the state wants at this point. But we're also seeing the defense fighting back there, you know, witnesses by accusing, for example, the professor who was called Professor Scholes, by saying that he was quite biased towards the athlete in his testimony and only to testify in this particular pre-sentencing hearings. So we're expecting quite a lot of high drama, but I must tell you that today the expectation, much speculation around the fact that one of the family members of Reeva Steenkamp, who she lived with here in Johannesburg, they often refer to them as Reeva's Joburg family. You'd recall that when she left Port Elizabeth and moved to Johannesburg to pursue greener career pastures, she'd met a friend, Gina Myers, and a celebrity makeup artist, if I may add, and moved into their home. And she became very close to Gina Myers, Kim Myers, as well as some of the other family members. And very important, this is going to be a very emotional witness. What they would then want to do is to speak more to the impact that it had, not just on Reeva Steenkamp's immediate family, but also some of her friends, or this Joburg family that she lived with here, which was pursuing these different career paths. But the expectation, the first people who identified Reeva Steenkamp's body were the Myers family. It was Kim and Gina Myers' brother, as well as the father. So they would perhaps be able to give an account as well of the relationship that Oscar Pistorius and Reeva Steenkamp had. That's certainly something that we've not heard about, I would say, from somebody who knew about the relationship. The Myers sisters knew about the relationship. Some have even said that Gina Myers was one of the people very close to Reeva Steenkamp. She's the person conversations with the Myers sisters about this new relationship, I guess, that she was getting into, and exactly how she felt. So a lot of speculation, I must say, even at this stage, about the fact that perhaps one of the Myers sisters will take to the stand here this morning and really would then get, I guess, a grave or much more detail about exactly what the relationship was between Oscar Pistorius and Reeva Steenkamp.
It should be another emotional and quite explosive day. But briefly, before you go into court, I know you guys are preparing. Just briefly tell me about Judge Masipa wants to wrap up aggravation of sentence today, but tomorrow's a public holiday here in South Africa. Are we going to see her come back on Friday to sentence Oscar, or is this going to be into next week?
Well, the initial agreement there, Eben, was that this proceedings would start on Monday and, of course, would conclude on Friday. But we're seeing, of course, again, the state bring its last witness here this morning. And then, of course, we'll see cross-examination get underway by Oscar Pistorius' lawyer, Barry Rue. And then it's really dependent on whether the defense will call another witness. We saw that Barry Rue indicate he would then see who the state will call next and then decide witness. So, you know, your guess is as good as mine at this point, whether we'll be able to wrap up until Friday. But some of the sources that we spoke to say, look, Judge Thokozile Masipa has just about this week to attend to this particular matter. So it really remains to be seen. We'll certainly have an indication a little bit later on this morning into, you know, where exactly we're heading here. But the initial agreement between all parties was that we'd be able to wrap all this up by Friday.
Thank you very much, Griselda Lewis, live, actually just outside the front door of the High Court there in the capital here in South Africa. Of course, it'll be another draining day by the looks of it. Looks like there might be a surprise witness there this morning. Of course, if you've just joined us, all arguments for mitigation and aggravation in the Oscar Pistorius sentencing procedures must be completed today. Yesterday, witnesses gave testimony providing the court with different views of Oscar from the emotional journey Reeva's father Barry spoke of to a prison official. That made a claim that Oscar was quite violent and aggressive towards. Now, to find out what his expectation is, we are joined, of course, in studio by law expert Alton Hart. Alton, very good morning. Nice to have you back with us.
Morning, Gibbon, and morning to the viewers.
Elton, we're asking our viewers at home, we're asking them a question today that relates to yesterday. Our question today deals with the murder pictures of Reeva Steenkamp. Now, Barry Steenkamp, in his very emotional testimony yesterday, came out and he asked the murder pictures of Reeva Steenkamp to be made public. Now, in your legal opinion, firstly, should that be allowed?
The thing is, like, at this stage of the fight, if one can put it that way, I don't think that picture should be made available to the public, because this can somehow get a public uproar as to the type of sentence that Oscar eventually gets, and with the public pressure that can come to the case, this might influence the judge to think in a certain way, and then most probably give the guy a heavier sentence than what she wanted to give him initially.
Yeah.
So at the conclusion of the sentencing, after sentence has been handed down, they can make it available. In actual fact, a police docket, once the state start pressing charges and the accused pleaded to the charges, then it becomes public document. So it's open to the public to see the information in these documents. So somehow I think some of the public members already saw the pictures, but I think to just openly make them available, and that will obviously lead to newspapers publishing these things, and it might negatively affect the accused's sentencing, the sentencing procedure that's currently underway. So I think if the sentencing has been dealt with completely, done, he's given whatever sentence the judge wants to give him, then I think they can make it public.
Now, I want to talk to you quickly about your view. You've been off base, been watching it from afar, the sentencing procedure as it started on Monday. I'm sure you've read up on it and you've seen a little bit of it in the media and so forth. What do you make of Gerry Nell's first couple of days? The analysts say, yeah, he absolutely butchered the defense in this case, and that they got a sense that Barry Roux almost gave up. That's why his mitigation of sentence was so short.
At some stage, and like you put it, even, I also felt that at some stage Barry was actually leaving it. Up until, I think, with that and Sister Mashabani, where he actually came back a little bit to try and bring this thing back into proportion. But also one should know that with murder, there's like a minimum sentence that hangs over Oscar's head. Yeah. This 15 years is hanging. But people shouldn't think that the judge is... They go read the act. Discretionary minimum sentences for certain serious offences. So it's still a discretion. So it might be that he's found guilty, but the judge might give him 10 years, say 5 years is suspended. So that's all the things that one should now take into consideration. But I felt like Barry left it some, because I thought he would be a little more aggressive towards the taking the state's evidence that they lead in sentencing. But also maybe he has some way of thinking, and we'll only see that what's happening today with the last two witnesses coming.
That was Barry Roux the first couple of days. Judge Thokozile Masipa. Now a lot of the attention has been focused on her because she was the one that made the culpable homicide finding. She's the one who got dolus eventualis wrong in this case. Surely there must be a lot of pressure on her now to not only get this done within the timeframes as we've heard, but also to come up with a satisfactory sentence, because in the original trial she had quite a sympathetic ear towards Oscar, if one can put it that way.
If one can put it that way, Evan. And the thing is, I think, like I said right at the beginning, Judge Masipa was between a rock and a hard place from the get-go. So this was one of those cases, and as I said at the beginning, this case was not TV ready, if one can put it that way, but we got it on TV. And this played also a major role on how the judge conducted herself in the trial. She didn't want to be seen as being harsh towards the accused because he's not found guilty of an offense, and she didn't want to see as she's not looking after the public's interest. So she had to have this balancing act all the time, listening to the evidence. And I mean, both Gerrie and Barry made compelling arguments for their respective cases. And she was really struggling to grapple this thing. And I think the issue of dolus eventualis, even for some seasoned lawyers, there's still that gray area as to how they look at things. They argued every day in court that there was intent, there was no intent. So it's not a done and dusted case. Because these things come to court every day, we just don't see it on TV. So she had a difficult time.
That is true. Just quickly, tell us about Barry Roos not cross-examining Barry Steenkamp, and then the decision not to put Oscar on the stand in mitigation of his own sentence.
The thing is, like, because Oscar, in his bail application already, he made a plea to the country or to the judge saying that this is who I am, this is what my position is. So that bail record is already part of the proceedings in court. So the people and the judge already has an idea as to what is Oscar's special circumstances, if one can put it that way. So cross-examining Barry Steenkamp, I think that was a tactical move because it shows that Oscar shows sympathy towards Barry Steenkamp, and that's why I didn't go after Barry, because people might get, if he's now starting grilling Barry Steenkamp, then they say, but this Oscar man doesn't have a heart. So I think that was a tactical move not to go, and more or less when he spoke to Barry, he was more sympathizing with Barry and saying, we feel your pain, and he even opened up the door for discussion that Oscar wants to speak to you. And I think that also can weigh heavy on the judge's mind, say, but this guy shows remorse. So when I look at the sentence, it won't be the 15 years that one should look at. So that people might see it as it's a weak move, but I think it was a tech move.
Elton, we're going to hang around. We've still got a lot of things to talk about, but let's take a short break. Before we go to the break, don't forget our question of the day. We're asking the question after yesterday. It's a very emotional day in court for Barry Steenkamp, the father of Reva, who you see on screen now. And he said he wanted the murder pictures of his daughter to be made public. What do you think? Should these murder pictures of Reva Steenkamp be made public? He says particularly he wanted to make sure that that the pain that she went through, he wanted people to see that. We've got some live tweets that's come in. Before we go to the break, let's just have a look at what Samantha says. Samantha says, Newsroom, it's Barry's request. Yes, make the pictures public. What do you think about that? Sunny Monster says, Newsroom, it will not help anyone. The truth is she died by his hands. Those pics is just a confirmation. Yes. Tony Roberts says, Newsroom, no, why now? Opening old wounds, let this rest in peace. What about Barry's wishes? Doc Moses Vilani says, Newsroom, yes, however, caution should be exercised so that it doesn't harm other victims of crimes and children. That is a rather sober view there. Prince Mduduzi says, Newsroom, yes, until justice is done in a good way, we all have to pay for our doings, says Prince Mdu. Well, I've just been informed we're not going to take a break because court is about to get in session. Let's go to the North Gauteng High Court for what should be the final day of aggravation of sentence.
Goed, maar ek kom laas witness Kim Martin.
Michelle Martin. Do you have any objection against taking the oath? No, I don't. Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Raise your right hand and say, so help me God. So help me God.
Thank you. You may be seated if you so wish.
Thank you.
Madam, you've given evidence in the court before during the trial we had in this matter. Is that correct?
Yes, I have, my lady. Yes, I do.
You confirm the contents of the evidence you gave?
Yes, I do.
Now, Madam, it's now a year and more later. Do you still think of Reba?
Every single day. Not a day goes by without thinking about her.
How are you coping?
My lady, coping, yes, because you've got to get on with your life. But the scars, the effect runs very, very deep. We'll never completely get over it. But I'm a mother of 3 children. I have to cope. I have to be an example for them. I have to give them hope for the future. They're at an age where they need to be able to make sense of what has happened. So I have to be strong for them. So coping, because we have to, yes. But getting over it, no.
And your children, are they coping?
I try, as a mother, do the best job that I can. They are young and find it very hard to process what happened. It's been 3 years now since the incident, my lady. And at different stages, I see different effects coming through on my children. I don't want to, for sensitivity reasons, explain exactly what my children have been through, as I did previously, because I've seen the effects on them, but they suffer very much because of this.
Has it changed your life?
Yes, it's changed my life completely. Besides the obvious depression, as a family, we'll never ever be able to carry on like normal. You know, just standing in the queue at a shopping centre poses difficulty. You know, people don't recognise you and they start mentioning the trial, or they start mentioning Oscar, or they start mentioning Reva. And you can never be prepared for what might come up. You know, I attended a workshop a couple of weeks ago, a self-awareness workshop. And without people realising, the lecturer started speaking about Oscar. And I just went cold. You know, it's never going to leave us.
You, apart from you, your children, the broader family, how are they coping?
My dad, for instance, is... I saw my dad cry for the very first time when Reva died, and I saw him cry for the very second time when he heard that I had to testify again. It's very unfair what our family's been put through. You know, losing a family member that was such a big part of our lives in the way that we did, and then to have to be exposed to the media, to have to sometimes defend ourselves, it's very difficult.
Talking about media, thinking of an interview that the accused gave to the media.
The only thing that I do know is what I've heard on the radio and TV, that he's going to be doing what he's done in an interview, and that it's going to be viewed on the 24th of June.
And how do you feel about that?
I'm not happy about that at all. I just think it's very unfair to want to talk to the world about your version when you had the opportunity in court to do so. And it's just... It's hurtful. I just don't understand why. I can't understand why.
So, as a family, you have Christmases and birthdays. How does that affect the family of Reba's?
It's terrible because we want to be there for each other. We want to be able to celebrate.
let every special occasion be about Reva being murdered, about not saying anything. We have to celebrate. We have for them, you know, my youngest daughter is 17 years old. She doesn't deserve to have every special occasion cut short. As it is, Valentine's Day is the worst day for us. Christmas, we all want to be together. We're going to set somebody off. We want to honor Reva's memory by leaving seating, like we said, by putting the candle out for her. But we don't want every occasion to become a funeral, you know.
And your Uncle Barry, how's he coping?
As far as I'm concerned, my uncle is a broken man. You know, he lives day to day on his phone, just watching the posts about Reva. The guilt as a father, not being able to protect his daughter. It's very difficult for him.
You've said during consultations that you expected something of the accused from the start. What was that?
I didn't hear your question.
You explained that you expected something from the accused from the start of the trial. What was that?
And my lady, all we've ever wanted is the truth. And I know people said, but you got the truth, but we didn't. Oscar's version changed so many times. And I never ever heard him saying that I apologize for shooting and murdering Reva behind that door. I don't feel there was an apology from him. I don't feel the true version came out. We just wanted the truth. That's what we wanted.
Thank you, my lady. Nothing further.
Yes, Mr. Chair.
Thank you, my lady. Ms. Martin, I was very, very careful when Mr. Steenkamp gave evidence because I understand the pain. But there comes a point and we also must focus on what's going on with the accused in this matter. And I've unfortunately reached that point. I'm going to read to you some transcripts and some interviews, including one of yours.
Okay, may I sit down?
Yes, of course.
Thank you.
And I will demonstrate and later argue to the court how everyone either did not know what was going on in the relationship or experience his relationship with the deceased as a good relationship. But then, after hearing rejected evidence in this court and media publications about rejected evidence, then suddenly he became the villain. And I'm going to take you through it. What was before this court in the bail application, and I just want to deal with the relationship between the accused and Reva, the deceased, and how it was experienced by her close friends. Samantha Gravenstein, that was undoubtedly her closest friend, described this in a statement that's part of the record. After saying that Reva was her best friend, paragraph 7, after a while Reva and Oscar started dating. Reva told me that Oscar was amazing and he treated her like gold, and that she thought they had a lot in common. Reva told me she really liked Oscar. The relationship slowly progressed and became more serious. Riva often mentioned how happy she was and that Oscar made her feel that way. And I want to read the second part to you, and then I will go also to what Gina Myers, another best friend, was saying. Paragraph 9. Riva confided in me that even though she and Oscar had not been together for very long, she really loved Oscar and she could see a future with him. She told me that if Oscar asked her to marry him, she would probably say yes.
Sorry, my lady, was this still Sam Cravenstein saying
That's
this?
right.
Okay.
Do you have any comment?
Yes, first I'd like to say that I didn't even know Sam Cravenstein, so she might have been quite close to Riva at the time, but I didn't know that she was even a friend of Riva's. And I asked Riva, and I was very close to Riva. Riva and I were like sisters. I asked her, "Are you happy?" And she said to me, after shrugging her shoulders, she smiled and she went, "We will speak later." I could see she was bubbly. I could see she was excited. And I could see there was a fondness for Oscar. But I did not see any. So Riva had opportunity to tell me that she loved Oscar, and she never did. We spoke over WhatsApp.
Is that as far as Riva went in discussing Oscar with you, to shrug her shoulders?
When I asked her, when I questioned her feelings for Oscar,
Yes.
and I questioned her happiness, that's as far as she went, yes.
And that's where it stopped.
Yes.
We'll get back to it.
Okay.
And we'll get back to an interview that you gave.
Okay.
And your previous evidence. And then you will see why I said in the beginning that I'm sort of concerned. Another friend also wanted to be described.
Very well. As far as I'm concerned, she was Riva's best friend.
Yes. There are two interviews, live interviews. The one with Mandy Wiener on 27 February 2013, so shortly after the event. And I'm going to read the question to you, and I think you can accept what I say, otherwise we'll play it. And how did she feel about the new relationship? I can tell you that was a reference to Mr. Pistorius. Answer. She was happy. I think in every relationship there's ups and downs, and you know stuff that you go through when it is a new relationship. But everything was normal. Let me read the second one.
Who was she interviewing? Sorry.
She gave an interview to Mandy Wiener.
No, who was?
Gina Myers.
Okay.
You want to comment on that or wait for the second one?
No, wait.
The second one was with Andrew Harding of BBC. Same day, 20. Question. Do you think Riva was happy? Answer. I did. And in a relationship? Yes. Any comment? To ask if you have any comment.
Yes, I know, thank you. I've heard lots of things about how Riva felt about Oscar. I don't really know what the point is. I mean, I know she liked Oscar. I don't think she loved him. I think she was very fond of him. I think she had a very soft spot for him.
Now, you said previously in your evidence that when you asked her about the relationship, she really didn't tell you, she shrugged her shoulders. And you talk later, but that occasion never occurred.
Correct.
Is that correct?
Correct.
So you don't really know what was in the relationship?
Correct.
Yeah. Can I remind you what your previous evidence was? And it concerns me, because the court must work on this. at page 3647, and then I will go to an interview that you had with Pierce. You were asked about it. You explained at the bottom of 3647. You explained that when Riva was an adult, she was living in Johannesburg. She confided in me what that relationship, what it was about, and what it had done to her, and how it affected her, and to what extent it was, how abusive it actually was. That was your previous evidence, and we know now you could not say that.
What relationship are you speaking about?
I object, yes, my lady. We should make sure that we're talking about the relationship with Oscar, because it's not.
That's not. I never said that about her relationship with Oscar. I said that about her previous, one of her very first relationships.
Well, if you're right, then I will apologize, because I'm reading it here. You say, do you say that it had nothing to do with Oscar?
That had nothing to do with
Then
Oscar.
I apologize. Then it's wrong. My understanding then is, and I really apologize, then it's a wrong reference to you. Let's go to the interview. Can you remember that you had an interview? It was aired 20 February 2013, shortly after the event.
Very clearly, yes.
And you were asked about this, and you said the following: would this be correct? When did Riva tell you that she was dating Oscar Pistorius? Can you remember that? That was the question, yeah.
Yes, sir.
You don't have. Can you answer? Well, I saw it in the news first, and that was about only 2 months ago. When it first came out, there was rumors. When she attended one function with him, and I remember I sent her a message, and I said, "Is it true, cuz?" And at the time she said, and that's basically it. She never really spoke much to me about him other than that. Would that be correct?
That's correct.
So all that you really know is that she described him as a nice guy. And that's as far as it went.
Correct.
You know about the Valentine's card that she made for him saying, "I love you"?
Other than hearing about it in court, no.
I have no further questions, thank you.
No re-examination.
Thank you very much, Mrs. Smart, for your assistance. You may be excused.
Thank you.
That concludes the evidence for the statement.
Thank you very much. Yes, Mr. Roux.
I'm so sorry.
Do you want to call any more witnesses?
No, my lady.
You don't. Are you ready to argue?
We're ready, my lady. May I just 1 minute just to get copies of the heads of argument? And then may I just hand to you a copy of our heads argument. And what I've done, I've prepared a separate bundle for the annexures there too, otherwise it's too voluminous and it's difficult to deal with. I will also, at the right time, it's just because I don't have it in my hand, give you the copies of the cases that we referred to. Just as a matter of convenience, my lady. Here it is.
Yes, yes.
My lady, to the format of our heads of argument, we took your judgment and then compared it to the judgment of the Supreme Court of Appeal to see what is different. And then at the end you will see we come to what we call the distilled facts, meaning what facts remain undisturbed and what is new and what is that complete picture, in order to try and present to you a complete picture based on a reconciliation between the two judgments, because it was not too difficult to reconcile them, as you will soon see. But before I deal with it, if I may say this, lady, there are serious enemies, so to speak. And the first one is that there was a perception created that the deceased wanted to kill the deceased. That direct intent theory. And it does not go away, because once you have created a perception, some people who wish to be informed and who wish to sit back and analyze the facts and put their trust in the court would then consider, was it really true that he wanted to kill her, that Dulles directors? Or is the finding very different because we know now the objective evidence, and I'll get back to that. And is it not perhaps a different picture? And to what extent has that different picture changed? It doesn't happen in this case. Sometimes understandably so, sometimes not. Understandably so when you have a father that's hurting, and what's in his mind, because what was put in his mind is there, and it's not for me to cross-examine him on the court's findings. You can only have empathy and sympathy with the parents. But the unfortunate part is that hurt, that pain is aggravated by perceptions created in this trial. That's the unfortunate part. The second one is, the second enemy in this trial is, there is from some part of the society an unwillingness or an inability, I don't know which one, to see this accused in the context of that evening. He's still portrayed in their minds and somewhere in the media as this person winning gold medals, the strong, ambitious person, 1.84 meters. And that would have the effect that become concealed. That takes away the real context, where it was not the man winning gold medals that must be judged. It is common cause. It was a 1.5 meter person standing on his stumps, 3 o'clock in the morning when it was dark. And once you start and want to see it, of course a very different picture would unfold. But if there's resistance to accept that, then of course it would so perfectly attach to the I wanted to kill the deceased theory. The third one is, once you have bad emotions about the case, like the emotions, the negative emotions caused by the first two perceptions, then many people have either an unwillingness or an inability to set the bad emotions aside and to look at the true facts and to say what really happened, instead of saying I don't believe it. I don't believe it means I don't believe times on cell phones I don't believe other objective evidence that I will come to. Not things that people thought. Objective evidence, we've dealt with it in a timeline. I distinctly remember this court asking the state, can you deny that? There could not be a denial. They were objective grounds. But if you allow perceptions to control your thought process, you would not even pay any attention to objective facts, to objective impossibilities. And that's the difficulty in this case. Those factors, and whatever sentence you impose, there will always be a group of people refusing to allow the true facts as found by the court, and for this instance the courts, to rather prescribe to them and to their emotions what an appropriate sentence should be. There can never be an appropriate sentence if you believe that he had an argument, he wanted to kill her and she ran to the toilet and he killed her, which are not the facts. Not because we don't think that they are the facts, because those facts were absolutely refuted by objective facts, not by say-sos. But I understand it in some instances when you go through pain. I understand it. I don't always understand it for people more removed. Why they don't want to sit back and look at the true facts. The fourth one, the fourth enemy is, and I've unfortunately seen this in different contexts, is that we have a concept in the criminal law that we call benefit after doubt. But what we then see when it comes to whether to convict or not, the court is trained in that process and experienced in that process. Say, well, you may have done it or you may not have done it, and it's not as fanciful possibility. I have a reasonable doubt, not a fanciful doubt, not just a distant possibility. I have a reasonable doubt that you didn't do it. But then when we get to sentencing, there's sometimes, and very much also in the minds of lay people, this perception that, but hang on, maybe he did it. And then you can't just sentence him because you have doubt. Maybe you must include a couple of years for that possibility, for that doubt. So the doubt becomes then the aggravating factor. Without saying to yourself, but hang on, how can I add years? How can I ask for a more severe sentence if not the probability is that he didn't do it? How can you add years? How can you now say, well, maybe he did do it and I'm going to punish, or I want him to be punished more severe? Those factors, those four enemies, remain in this case. Whatever I'm going to submit to this court, whatever I'm going to say about your judgment and the Supreme Court of Appeal, not this court, society. Unless the members are prepared to say, should I not just sit back and think for one moment that there might be another version and it might be true, and what then? What if it is so? What would I want then to happen to this man? And the brilliant example that we have, most of us remember that very, very tragic incident of Vleis Versace, a well-known rugby player, where he saw sometime late night his car driving out, living on a plot. And he thought someone was stealing the car, and he fired a shot, and it was his daughter, and it killed her. It was not right to fire the shot. Of course not. And if you analyze it in view of the Supreme Court of Appeal judgment, when he at the very least foresaw and reconciled with the possibility that he could kill that person, it's murder dolus eventualis. But everyone sympathized with him because they understood, and he was not prosecuted, if I may add. He was not prosecuted. There's a statement by the prosecuting authorities to say, it's not right to prosecute him, it's inappropriate. And I agree. But that's not the point that I'm making. I'm not asking for a non-prosecution. But everyone understood that you can make a mistake where you shoot at the person under a mistaken belief, and that you're law then guilty because you still shot at a person. But then there comes this little tail back to it, and it's again converted into he wanted to kill the deceased. Everyone in the Vleisversagie understood, and when you ask everyone, they would say, it's terrible. It's of course terrible. I think so often about him. How must you feel when you know you should not have fired that shot at your own daughter? But maybe not exactly the same class, but how must you feel when you fire those shots that you should not have, and it's your own girlfriend? But that privilege, that thought process, in some instances, remain absent. And what do? We criticize without sitting back and following the process. And that is what we try to do in the heads of argument, my lady, where we say, you have a number of questions to answer. The first is, of course, that the prescribed sentence, the discretionary sentence, as they call it nowadays, that it is 15 years for murder, unless, of course, you find substantial and compelling circumstances. And we will take you through the heads of argument to explain why we say there should not even be an argument that those substantial and compelling circumstances are present in this case that would allow you to deviate from the discretionary sentence. We say to you, and we refer, and that's page 3 of our heads, my lady, we refer you to the Malgas case, and then a very, very useful application of the principles in Malgas in S versus Vilakazi. And what it really tells you, in short, and you've heard it so many times, my lady, and I'm sorry to repeat that. It says that, and I go to page 3 of Malgas. The first one that's important is paragraph 9, where the Supreme Court of Appeal said the following: I can see no warrant for deducing that a legislature intended the court to exclude from consideration ante omnia, as it were, any or all of the many factors traditionally and rightly taken into account by courts when sentencing offenders. So it's not that you must now suddenly something extraordinary, something special, something exceptional. It's not true. And it is so well put in paragraph 22 of the Malgas case. And that only a court can understand, because a court is trained in understand that feeling that you get. When you look at the facts, you get that distinct feeling, this is more or less where I should go. And it tells us what that feeling is. It says, the greater the sense of unease a court feels about the imposition of a prescribed sentence, the greater its anxiety will be that it may be perpetrating an injustice. Once a court reaches the point where unease is hardened into a conviction that an injustice will be done, that can only be because it is satisfied that the circumstances of the particular case render the prescribed sentence unjust, or, as some might prefer to put it, disproportionate to the crime, the criminal and the legitimate needs of society. And I submit that there must be an unease when anyone tells you you must send Mr. Pistorius 15 years to jail, where it's a man that was on his stump 3 o'clock in the morning who did not want to kill his girlfriend, who believed, and I will show you later, that this finding by the court is understood, who believed that she was at the time in the bedroom. that's undisturbed. Do you send that person 15 years to jail? How is that so far removed from Vleisversagie case? How is it? There are differences, but is it so far removed that the one should not be prosecuted and the other one must be sentenced to 15 years? We submit that unease and that anxiety must be overwhelming in this case. And that only would indicate one thing: it cannot be. It cannot be, provided, and this court has done it, provided that you prepare to entertain the correct facts and not to be drowned by the many perceptions, provided that. Because if you allow yourself to be drowned by perceptions, by wrong facts, any sentence will do. The same was then said, I refer to Vilakazi, and I've underlined in paragraph 15 on page 4 that one part where it says, with reference to Malgas, that the provisions of the Act vest the sentencing court with the power, indeed, the obligation to consider whether particular circumstances of the case required a different sentence to be imposed. And a different sentence must be imposed where the court is satisfied that substantial and compelling circumstances exist which justify it. I'm not going to read all of it. It is there on page 5, my lady. I will then go and ask you to go to paragraph 6 of the heads of argument. Page 6, my lady, I'm sorry. It says the SCA judgment. And we say to you, my lady, that when, for the purpose of this case, when considering, just the abbreviation, the Supreme Court of Appeal, it's no disrespect. I have huge respect for the Supreme Court of Appeal, of course. When considering the SCA judgment in relation to the present sentencing proceedings, it must be borne in mind that the SCA did not reconsider the merits of the case, but considered questions of law relevant to dolus eventualis and error in objecto. As such, we say to you, my lady, that the legal and factual basis upon which this honourable court relied for the imposition of sentence remain valid unless different findings apply as a result of the SCA judgment, and then only to that extent. We submit, my lady, that it's in this context that the SCA judgment must be considered and applied to the undisturbed factual findings made and applied by the trial court. What we then do, my lady, we then proceed to the SCA findings. So we first isolate them, and you will then see a later process where we combine them and say, well, let's look at the trial court's finding and to the SCA finding and to see what the position is. Paragraph 13. The SCA found that in discharging the shots, the accused acted with dolus eventualis. And let's immediately say, not dolus directus. There is nothing in the SCA judgment saying there was an argument, saying that she ran to the cubicle, saying that he wanted to shoot her. That's not this court's case, and it's not the case in the SCA. It is a very different case. And before I read to it, in short, it is this. When he fired the shots, this court was of the view that he was genuinely in fear of his life. And the fact that he did not fire chest high but lower had this court in a position where the court had to consider, would this now be culpable homicide or dolus eventualis? And the court very carefully considered the two and ultimately came to the decision, because of the subjectivity of the mind, that it was culpable homicide. And to sentence, the court made it plain and clear that, and it explained to us that process that the court must have gone through, that whatever I found, it bordered on dolus eventualis. So we're really talking here on a difference in view whether it bordered or whether it was. And that's all. So the SCA found then, we say in paragraph 13, the SCA found that the trial court had concluded that dolus eventualis had not been proved premise upon an acceptance that as he had thought Riva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that the accused did not realize that it was Riva in the toilet. He did not foresee that his action in shooting could cause her death, and he could not be held guilty of her murder. The SCA found that the above finding went to the heart of the first question of law reserved, i.e. whether the principles of dolus eventualis, including so-called error in objecto, were properly applied. And the SCA found then in this regard, what was an issue therefore, and this is so important, was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might. This is so important. Finding that he genuinely believed at the time of firing of the shots that Riva, the deceased, no disrespect, absolute only respect when I refer to her, was in the bedroom is undisturbed, not reconsidered. So how, when I look at Vleis Versace, when he thought it was a thief driving away in his car, he also had a mistaken identity. The mistaken identity is not wrong. It's not taken away from the accused. It is a legal principle to say it does not help you in law because you still fired at a person, notwithstanding the fact that the deceased Riva was in a bedroom. But what do we have now? We get this impression that the SCA judgment is now that he wanted to kill the deceased, that he did not believe that she was in the bedroom at the time of the firing, that he did not believe it's an intruder. That's not right, my lady. It is so wrong. That is not the finding of the Supreme Court of Appeal, and it was not the purpose of the appeal before. They made it clear that they're not there to reconsider your factual findings. It was on that one aspect, and I'll come to that. In 13.3, the SCA further found in was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door. The accused incorrect appreciation, that is so important. It's there. The accused incorrect appreciation as to who was in the cubicle is not determinative of whether he had the requisite criminal intent. There is his incorrect appreciation. It's not rejected. What was his incorrect appreciation? His incorrect appreciation was twofold. One, that the deceased was in a bedroom at the time, and two, that an intruder was in the cubicle or toilet. That was his incorrect appreciation, but in law it did not help him. It goes on. Consequently, by confining its assessment of dolus eventualis to whether the accused had foreseen that it was Riva behind the door, the trial court misdirected itself as to the appropriate legal issue. Then paragraph 13.4, the SCA further found that the trial court's finding that if the accused had intended to kill whoever was behind the door, he would have aimed higher than he did not assist the accused, as it was inevitable that a shot fired through the door would almost certainly have struck the person behind it. Vleis Versace. When you fire at the car when the person driving it, likewise, inevitable, that would almost certainly strike the person. Consequently, that's paragraph 13.5, the SCA found, in these circumstances, I have no doubt that in firing the fatal shots, the accused must have foreseen, and therefore did foresee, that whoever was behind the toilet door might die, but reconciled himself to that event and gambled with that person's life, not Riva's life, that person's life. This constitutes dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. Then, as to the defence of putative private defence, the SCA found that the defence of putative private defence implied rational but mistaken thought that even if the accused believed that there was someone else in the toilet, his expressed fear that such person was a danger to his life was not the product of any rational thought. So what the Supreme Court of Appeal says, and we'll deal with later, he says, although frightened, I just don't, your fear that you thought that you could fire the shots was not rational. And I'll come back to that, how you should approach this in sentence, where the case law tells you, when you deal with sentence, and then you look at a person's subjective mind, and we will deal with that when we deal with his vulnerability. And further, although he may have been anxious, it is inconceivable that the rational person could have believed he was entitled to fire at this person with a heavy caliber firearm without taking even the most elementary precaution of firing a warning shot. But that does not mean that he did not believe that Reva, the deceased, was in the bedroom. That does not mean that he did not believe it was an intruder. It is just that it was not rational and therefore not genuine to believe that he was entitled to fire the shots. That's it. No more, no less. The SCA found that this constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully. Interesting word. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, most certainly no one's going to say that he was frightened of Reva, the deceased. For the person still not wanting to believe this, are they saying that he was frightened that she attacked him? What would the thought process be? There cannot be such a thought process. Who was he frightened of? The deceased or an intruder? It's only one person. It's 3 o'clock in the morning in the dark. There's only one person that you could be frightened of, or perceived person, an intruder, not your own girlfriend. So I read again. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, the accused fired without having a rational or genuine fear that his life was in danger and the shooting was lawful. Mr. Fasaki, firing the shot. He could not have a rational fear that he was entitled to shoot and that his life was in danger. The person was driving out. The person was driving out, but there we have the sympathy from some part of the public. There we have the sympathy. He made a mistake, but not Mr. Pistorius. No, I will come back because of all the wrong evidence and the refusal to accept a proper analysis of the evidence, to show the impossibility and the unreliability of that evidence, they stick to it. We say then, and then the court found, obviously, the Supreme Court of Appeal, that the defence of putative private defence could not be sustained. And then it follows that there must be a conviction not of dolus directus, but dolus eventualis. We respectfully submit, my lady, that what we then do, we say it's necessary to reconcile the findings of the trial court in judgment and in sentence with the above findings of the Supreme Court of Appeal in order to consider a just sentence. Factors which arose subsequent to the original sentence must also be considered, and then that proposed sentence must be blended by the well-known concept in court imposing sentences, and that is the concept of mercy. We deal with moral blameworthiness, and may we make this submission. Once you have a reduced moral blameworthiness, that any court would say you qualify for the minimum prescribed or the discretionary sentence. Because factually, it's wonderful that you have remorse, and it's wonderful that you have 5 children to look after, and that you go to church every day, and that you donate money for charity. They're additional smaller factors. What is really important in a case? You look at that person's moral blameworthiness to determine who is it that I'm dealing with. You get this person, he rapes a 3-year-old little girl, and you ask him why, and he doesn't want to explain to you, or he doesn't give you a reason, or he just did it because he wanted to do it. You understand the moral blameworthiness and the total absence of a reduced moral blameworthiness. And you compare that with a person that that's 1.5 meters high, 3 o'clock in the morning in the darkness. And he thought, incorrectly, that he's firing shots at an intruder. And you say, can you mention it in the same breath? And you immediately realize that per se, we're dealing with a reduced moral blameworthiness, and per se we get that when we deal with dolus eventualis, because dolus eventualis only means one thing. I did not really have the direct intent, evil intent, not that murderous intent. It is rather what you foresaw and you reconciled this. It's a further step down. It's softer, with a harsher result, but the moral blameworthiness is softer, my lady. We refer you to the case, we say, when considering the moral blameworthiness of the accused for purposes of sentence, a court must look solely at what an accused believed, because we're dealing with sentence now, my lady, not the conviction, and intended when deciding whether he had reduced moral blameworthiness. We refer to Ferreira and others where it says the criterion for determining moral blameworthiness, it is said, is subjective. This means that one must look solely at what an accused believed and intended when deciding for purposes of sentence whether moral blameworthiness has been reduced. Substantial and compelling circumstances would seem self-evidently to reduce it. It seems to me that the true question to be answered is whether the threat from which each sought to escape was still subjectively perceived to be real and present danger, albeit, and it's so important, not imminent enough to escape criminal liability altogether. This could have been the Pistorius case. At the time of the offence, I say so, and then it goes on to the facts, which are not too important. Now, what we do, we say, now let's shift the focus to the trial court's finding, and it's no disrespect when I refer to this court as the trial court.
Well, it is the trial court.
Yes, it is, but yes. I mean, I should every time say the honourable trial court, but it's just for purposes of short sentences. So would you please read in, I say it softly every time, my lady. The trial court accepted, and we've got the judgment here. The trial court accepted that at 3 o'clock, the accused heard a noise, which sounded to him like the bathroom window opening. He believed an intruder had entered the house through the bathroom window. The trial court found, and I quote, the bathroom window was indeed open, so it was not his imagination at work when he thought he heard the window slide open. He armed himself with a loaded firearm and went to the direction of the noise. I still quote, he heard the door slam shut. The toilet door was indeed shut when he fired 4 shots at it after he heard movement inside the toilet. Now the important part, my lady, with respect. These findings remain undisturbed by the Supreme Court of Appeal. It was not the duty of the Supreme Court of Appeal in a question of law to reconsider your facts. It did not. These findings remain undisturbed. The accused approached the bathroom in the belief that an intruder had entered his house. He did so, and that was his evidence to protect himself and the deceased. That protection that he wanted to protect the deceased, that's now gone. He's now a villain. Because the perception is the Supreme Court of Appeal said he murdered the deceased, without saying what are the true facts. I say again, the Supreme Court of Appeal did not correctly so, not reconsider this finding. 2. The trial court found that at the time of the shooting, the accused believed that the deceased was in the bedroom. The Supreme Court of Appeal did not reconsider the trial court's finding at the time of the shooting that accused believed that the person in the toilet was an intruder and that the deceased was in the bedroom. The fact that the accused is criminally liable on account of dolus eventualis and by applying the principle of error in objecto does not mean that the accused foresaw that it was the deceased in the cubicle and that he reconciled himself with that. That is clear. I've dealt with that. It was pointed out. The accused's actions remain goal-directed to protect himself and the deceased, and the fact that his actions did not meet the legal criteria for a defense of putative self-defense does not mean that his subjective state of mind was not that it was an intruder in the toilet and not the deceased. That remains. As was stated in Ferreira, the true question to be answered is whether the threat was still subjectively perceived to be real and present danger, albeit not imminent enough to escape criminal liability. The accused believed that it was not the deceased in the toilet but an intruder also does not defy logic. I say this we say this by the by. It's not that you come and tell me something that is so absolute nonsense, so illogical that it does not make sense. And we say, who else other than an intruder would have entered the house at 3 o'clock? In your mind, when you hear that noise in the bathroom and you believe that it's not the deceased, who else would enter 3 o'clock? Someone coming to clean the house? Someone coming to buy the house? Or who? We know where we live. We're fearful. A logic thought process would be an intruder. Furthermore, we say, my lady, his belief that it was an intruder in the toilet was supported by his actions when he realized that it was the deceased in the toilet. This was further confirmed by his actions thereafter when he frantically took all possible steps to try and save the deceased's life. The trial court found that the seemingly incongruous conduct of the accused to go to the bathroom instead of taking evasive action, if I may say, my lady, with respect, the trial court was in this privileged position to see, to hear, to feel, and analyze every bit of evidence. And the court found it was explained by Professor Derman as a fight as opposed to a flight response. The trial court correctly rejected that as a defense. Correctly so. We didn't appeal it because we thought it was correct. But that does not mean that it doesn't explain his actions. The trial court accepts that the accused, that's the finding of the court. So let me read it correctly. This court accepts that the accused is a fight rather than a flight reaction person, as Professor Derman testified. We say that the SCA, the Supreme Court of Appeal, did not reconsider this finding, and the finding remains. We say it demonstrates that when the accused proceeded to the bathroom, he was not driven by evil intent. We so many times deal with that concept of evil intent. I wanted to say where I don't like my junior, but I thought that would be close to the truth, my lady. I'll get someone else. But I say I don't like a person, I'm going to kill that person. That's evil intent. The trial court found this court also accepts that a person with general anxiety disorder, as described by Dr. Foster, would get anxious very easily, especially when faced with danger. It is also understandable that a person with the disabilities, such as that of the accused, would certainly feel vulnerable when faced with danger. And that's the point, one of the enemy points I make. Some people refuse, point blank, to see in context the true facts. To see a man on his stumps, it's out of balance. That's vulnerable. That's not vulnerable from that day. That suffers the slow burn effect, that pervasive effect of vulnerability. The court found that. They want to see Oscar Pistorius running to the bathroom with his gold medal around his neck. That's what they want to see. They don't want to make that conversion from 1.84 to a vulnerable person in the darkness, 3 o'clock in the morning, on his stumps, without balance, suffering from an anxiety disorder. Those are the true facts that's found by this court. We say that the SCA did not reject the findings of the trial court, that the accused was anxious. Rather, the SCA found that although the accused may have been anxious and although he was frightened, a rational person could not have believed that he was entitled to discharge the shots. Now we know a rational person. But we also know that when you stand on stumps and you're not balanced, and you suffer from an anxiety disorder, The SCA, the Supreme Court of Appeal, did not reconsider the finding that the accused suffered from an anxiety disorder and that he would certainly feel vulnerable when faced with danger, and those findings remain. The SCA found that although frightened, the accused armed himself, that's paragraph 54. The accused could only have been frightened, we say, because of his perception that an intruder had entered his house. Why else was he frightened? Most certainly could not have been frightened of the deceased. We get back to the trial court's findings. The trial court found, quote, the version of the accused was that he fired shots at the toilet door because he thought there was an intruder inside the toilet. The sequence of events, namely the shots, the screams, the shots for help, the sounds of the cricket bat striking against the toilet door, the calls made by various witnesses to security to report screams and shots are more in line with the version of the accused. I looked at that sequence again. It was perfect. And it's so sad, my lady, and it's not supposed to be before this court. But we cannot escape it that when you look at new investigators and they tell the world that actually the shots were fired last, the cricket bat was first, hit the door open and there was cricket bat marks on the deceased, and you think, why are people doing this when all the experts in this court agreed that first of all, the shots and then the bat. You would remember, my lady, there was a crack in the door and it deviated around the hole, which the state expert said clearly, first the shots, then the cricket bat. The defense expert said clearly, first the shots. That's the evidence. Irrefutable. You see it. So why would you want to change that around? And once we know that, it started to make sense. Because then we know the second expert, Professor Simon, absolute expert, said, if the shot's there and you look at the fatality of the wounding, it was not possible for the deceased to have screamed. It could not be. That's confirmed by Dr. Stipp. That's confirmed by Professor Botha. But now you have witnesses who heard a woman screaming, and the court said they're unreliable. They're unreliable for many reasons. But inter alia, they're absolutely against the objective facts, against the experts. They're against a timeline. We could, within 30 seconds, determine when the shots were and when the cricket bat, because we had the times when people say, I've just heard shots. And you could see the time of the call. But somehow, people would refuse to entertain it and say, she was screaming and running away, knowing it's impossible on the objective facts. It remains and is punished forever and ever. You would have heard the evidence of Professor Skoll saying he was in a grocery shop. It's a murder, I don't want to be in the same shop. Well, what is that? What is that? Murder of what? That he thought it was an intruder? What is the scene? And that is what is going through, because people, some people refuse to sit back and look at the true facts. Then we say, where the court explained the correct sequence of the event in the trial court, the SCA did not to do so. And then I've already done it when I referred you to the factual position of the telephone calls, the screaming, and by the way, the direct neighbor saying, well, this Oscar screaming, that's all gone. They don't want to hear it. It doesn't accord with your perception that you want to follow. 17.6, bottom of page 15, my lady. The trial court found that in its totality, the evidence failed to establish that the accused had direct intention to kill the deceased. I wish I can read it 10 times, but I would not do so, my lady. And then we say, dolus directus, and because dolus directus is, I wanted to kill the deceased. That's rejected on objective facts, not on maybe you did, maybe you did not. We know the facts, we know the timelines, we know the evidence, the expert evidence. we say dolus directus remains rejected by the SCA, both with regard to the deceased and the perceived intruder. The SCA explicitly limited the scope of its inquiry to dolus eventualis at paragraph 24. And I just read where it says, this court cannot interfere, for example, with the factual decision made by the trial court rejecting the state's version that there had been a disagreement between the accused and the deceased that led to the deceased to hide herself in the toilet, to escape from it before being shot. Clear, unequivocal. The Supreme Court of Appeals say, that's not what we're called to do. He summarized that finding. He says, we're not called to reject that. The matter must therefore proceed, as was accepted by the state, on the basis both that it cannot be reconsidered and that it has not been shown that the accused has acted with a direct intention to kill the deceased. The state's case before this court therefore revolved primarily on whether the trial court had erred in regard to the issue of dolus eventualis. Appeals finding of murder is dolus eventualis and not dolus directus is also clear from inter alia paragraphs 51 and 55 of the Supreme Court of Appeal judgment and its order. In 51 it says, in these circumstances I have no doubt that in firing the fatal shots the accused must have foreseen, and therefore did foresee whoever was behind the door, might die, but reconciled himself to that event occurring and gambled with that person's life. This constituted dolus eventualis on his part, and the identity of the victim is irrelevant of his guilt. And 55, in the result on count 1, the indictment, the accused ought to have been found guilty of murder on the basis that he had fired the fatal shots with criminal intent in the form of dolus eventualis. To say the blue jeans were lying left or not right, or the fan was 3 meters to the left or to the right, or whatever, because that was part of the evidence to try and support this attack that it was dolus directus. It's irreconcilable with the finding that at the time of the firing of the shots, that's the remaining finding, that the accused believed that the deceased was in the bedroom and that he was firing shots at an intruder. That would be, to go to that would be a poor and wrong and contentious attempt to reintroduce dolus directus, a defense rejected by this court and not reconsidered by the SCA. The SCA made it clear that that version remains rejected, to use the words. We say in paragraph 17.6.3, the undisturbed finding of the trial court that the accused did not act with direct intent is further supported. I don't know why I'm going there because it is so clear already, but let me go there, by the following. If the accused had direct intent aimed at chest side and not lower and downwards, the accused was on his stumps, which invariably would have made a downward trajectory lower than that of a person of full height. What am I saying? I'm saying this. Even if you work with the intruder, there's never a finding that they had direct intent to kill the intruder. It was once suggested by the state in the bail application. It is so wrong. Because the finding by the court that he did not aim chest high but lower, that finding remains. Now, if I really want to kill you, direct, I'm not talking about dolus eventualis. I don't stand on my stumps and aim lower. I aim chest high. It's a different story to say, but of course in still firing, you should have foreseen. I understand that you did not mean to directly kill, but you should have foreseen that you could kill the guy, and that was the finding by the SCA. You should have foreseen and you reconciled yourself. You did. You should have foreseen, therefore you did foresee and reconciled yourself. That's the finding. Not that it was a direct intent to kill the intruder. The same principle applies there. 2, we say, if the accused wanted to kill the deceased, he would not have taken all possible steps to save her life. I'm just going to the deceased. Only so that she could expose him as the person who wanted to kill her. The trial court specifically found that the accused's actions in trying to save her life, after he had realized that he had shot her, were supported by the evidence and were not faked. This finding also remains undisturbed by the Supreme Court of Appeal. What we then do, my lady, we have now analysed the judgment and then go to and we say to you, on those facts, it should not even be a dispute that there are substantial and compelling circumstances. There's a reduced blameworthiness. He stands before you on murder, and we know that what the man wanted to do in his vulnerable state was to protect himself and the deceased. And he incorrectly in law fired 4 shots and is guilty of dolus eventualis murder. But it does not mean that he did not want to protect. It does not mean that he was not scared. It does not mean that he did not think it was an intruder. It does not mean that he was not vulnerable. It does not mean that there were many supporting facts indicative that it was an intruder, the window opening, door shutting, and so on. They all remain. You cannot ignore that. We say when we look then at the mitigating factors, my lady, may I just ask for a 2-3 minute adjournment? Just a 2-minute adjournment. Just need to clear the throat before I deal with the next one.
Court will adjourn.
Did you go to heaven?
Kelvin is the one who created all this.
What are you fighting over? Us?
If there is 10 million in my account, it will be in the front page the next day.
Do you have 10 million?
Oh, Jesus, hold my hand. Hallelujah.
It's happening right here on Question Time today.
Monday to Thursday at 5:30 p.m. on the SABC News Channel.
One other person has been shot dead and another is in a critical condition in hospital.
The CRL has laid charges against controversial televangelist Paseka Motsoneng.
More than 1.3 million South Africans have been added in the past 2 registration weekends.
The International Monetary Fund warns that policy uncertainty could dampen economic growth in South Africa.
And all eyes are on the new Bok coach, Alistair Coetzee, his challenge to keep everyone in the country happy.
News locally and around the world.
When Judge John Hlophe challenged the Supreme Court of Appeal when it sent the matter back and said that there must be an inquiry set up.
We unpack business news.
There's an increase in general inflation in the country.
We give you up-to-date news of the day.
The drugs were seized at several locations in Sydney, including a shipping container sent from Hong Kong. Police saying it's their largest haul of illicit drugs in 2 years.
We round up sports news.
Kosata, tell me about the legacy that you would like to build and be remembered for.
Trying to get my foundation running, which is going to focus on, all the sport, doesn't matter disability or able body. So, I'm passionate about sports.
Stay informed every Monday to Friday from 3 to 5:30 p.m. CAT. SABC News.
Attorney Elton Hart, and it's been a very interesting morning, has it not been?
Indeed so. Many things came up and a lot of talking points.
One of the things that we picked up from yesterday was this is still a very emotional case for a lot of people. Besides service, it's touched by a lot of the testimony. In fact, we saw for the first time Barry Steenkamp, Riva's father, on the stand testifying to how he hears his wife crying at night. Even though she seems stony-faced and hardcore, she cries at night. You can hear her. And he himself was crying in court. A very unpleasant scene for a lot of people. What do you make of what's going on in court so far?
Obviously, if I look at it, and the state would obviously want to put aggravating factors before the court, showing why Oscar should be subjected to the minimum sentence, which is 15 years. And obviously, this morning we see Barry Roo is busy putting mitigating factors before the court why Oscar should not get the minimum sentence of 15 years. So this is my part and parcel of the procedures during sentencing, where you have to bring mitigating and aggravating factors. The state will normally bring aggravating and the defense mitigating. And that's how you have to work the process.
Now, Kendall, you were saying a little bit earlier, remorse is playing a very big part in this trial. And what kind of, what will the judge make of these kind of remorseful situations that we're seeing?
And yeah, I can knock onto this because me and Kendall had a little bit of a discussion also offline about this. And the thing is, like, normally why the SCA, the Supreme Court of Appeal, send the matter back to the trial court to actually give a sentence, because during the trial, as proceedings go on, the judge is exposed to the demeanor of the accused person while sitting in the accused box. So that plays a role in the sentence, because the judge wants to pick up, is this person remorseful for whatever he or she has wronged? And they look at that, and those kind of things are normally critical to decide, am I going to give him the maximum penalty, or is he already paying in some way or the other for what he has committed? And this morning you can see, and Barry is currently busy in court trying to show that even there was an incident in a supermarket where a woman just screamed and yelled at Oscar, where she's saying, this murderer, I don't want to be in the same shop with him. So indirectly is also suffering the brunt of the bigger public when they see him. Some of the public members is more sincere towards him, but a bigger portion of the public is actually feeling that he's a murderer and he should be sent to jail. So those are the things that you need to now play on, and the moral blameworthiness. He was now coming in with it and say that these things, and see the moral blameworthiness of Oscar in this case should not be that heavy, because there's other factors that influence him, and we shouldn't see him as this Olympic gold-winning medalist, the guy full of confidence. We must look at him now, currently, as the psychologist said, he's a broken man, a 1.5 tall person.
Very interesting that the words used in this case seem to be swaying people one way or the other. For example, bringing in the argument of moral blameworthiness. When Barry Roo brought that up this morning, he compared Oscar Pistorius' act to that of a pedophile raping a 3-year-old child. Now, obviously, that already puts an idea in your mind. It's a reprehensible act to rape. And it's even more reprehensible to act violently towards a child in that manner. With that said, we know that Barry Roo wasn't happy with the way that the proceedings were going. In fact, I see we are going to have to cut off our discussion and carry on later. Court is back in session. Barry Roo speaking, and I'll be asking the question again later.
And it is this, that we may or may not again hear about he was a poor witness and he contradicted himself. That's there. The court judgment, the trial court judgment, considered that. And after finding that, came to certain findings. So it has served its purpose. The Supreme Court of Appeal considered that, remarked on that, and brought out its finding. So it fulfilled its rightful place in coming to judgment, and again in coming to judgment. The poor witness and the contradictions do not change the findings, because the findings are made consequent upon it. It was first a finding of poor witness, and then say, well, let's accept it, but let's see what remains. Let's see, having regard to the fact that you're a poor witness, that you vacillated, that you contradict yourself. Let's see what remains, and that is what we're dealing with. What remains? And I think when Professor Scholes gave evidence, Mr. Nell remarked a third version. It's not a third version. All, if you read in context the whole page, all that Professor Scholes was saying, he accepts now, because the judgment is there, that he intentionally shot. He accepts it now. That was not his version, but he does the right thing. You have no choice to accept. We must accept court judgments, and it shows he's moved on. He accepts the blame, and he says, I accept it. That's the judgment against me. What must I do? Kick up dust and fight all the time, or respect? It's an acceptance of what was attributed to him by the courts. It's there. With that in mind, I move then to page 18, my lady, to look at what we call the mitigating factors recognized by the trial court in the previous sentencing hearing, undisturbed by the Supreme Court of Appeal, which further contribute to the existence of substantial and compelling circumstances. It would be those circumstances that don't really impact on his moral blameworthiness, but the balance of mitigation. And my understanding of paragraph 9 of Malgas is that you take all factors into account for compelling circumstances. That's already there. It serves a dual role. One, it's you can also use it for compelling circumstances, but also for mitigation. And these are the factors that we refer to. We say at the previous sentencing, this honourable court found the following circumstances to be mitigation, which mitigating findings remain undisturbed and relevant for purposes of sentencing. 1, it was the personal circumstances of the accused as described by the court. We give the page references, 2, that the accused is a first offender. It's all still valid. 3, that the accused is remorseful. We don't have to argue those findings. 4, the accused lost a person whom he genuinely loved as a result of his unlawful shooting. He must live with that for the rest of his life. What must not be forgotten in the clamour of public punitiveness is that the accused has lost his love relationship at his own hands. In the report by Professor Scholes, and we give the lines, Professor Scholes explained the intense sorrow of the accused and his self-punishment and inescapable guilt. We say that the state has shown compassion for this kind of human tragedy before. We refer to Rudy Vleisversace. I'm not going to repeat it, just to give you the reference there. We say the accused apologized to the parents of the deceased in court after having made concerted efforts before to do so in private. The conduct of the accused after the incident showed that the accused wanted the deceased to live. All findings by the court there, we give the sentencing reference. But then if I may explain, when you say sentence 1749 and then 3504, what it simply means, there are 2 bundles. The one is the original bundle, the 3504, the trial court bundle, and then there was a reduced bundle for the Supreme Court of Appeal purposes. So we just gave you both page numbers.
Thank you.
It's the same page, just differently paginated. The mental and physical vulnerability of the accused constituted a substantial challenge for the accused. That's a finding by this court in sentence. And we say that the pervasive influence of vulnerability on the thought process and actions of the accused should not be underestimated. The negative impact of media reports on the career prospects and reputation of the accused is beyond dispute. We give that in the court sentencing and also where Professor Scholes refers to that. And then we say in addition to those findings, the following mitigating factors exist. We say the accused has lost all of his assets and his career. He's never ever resume his career. The accused has punished himself and will punish himself for the rest of his life far more than any court of law can punish him. I may say here, my lady, it is really, and I say it with absolute understanding, it is understandable within the context of grief and the belief that the shooting was because of anger and not as a result of thinking that it was an intruder, that someone would be calling for punishment and would find it very difficult to forgive. The fact that that was not the court's finding is irrelevant. We understand that. We understand that. But what we also understand is that must also look at the other side. There is a flip side, and that is the accused has paid from the minute he fired the shots and will pay for this for the rest of his life. It's not going away. He lost his future with his chosen loved one. He has paid physically, losing his health. He has paid emotionally. We say he's a shell of the man that he was. We know in the evidence, not only by Professor Scholes, but also the pastor. And the pastor was never challenged on that. He's a broken man. He has paid financially. He's left being dependent on others. He's paid socially. He's judged and vilified by many and verbally attacked. He is paid by the loss of his identity. He's a person filled with self-loathing and loss of self-confidence. He's paying constantly. Entitled to it. And it's there, and you must take it into account. We say in paragraph 20.3, the accused cannot bring the deceased back, but he can commit himself to public service in honour of her memory. We say that the accused, and that was the court's finding, the trial court, that the accused's contribution, as he gave his time and money to various charities and institutions, he has helped change the general public's perception of disabled people and inspired disabled young people particularly as he grew and excelled in his career. And it's not the only family, it's just we're privileged to have one person here to share that with the court. 20.4, after his release, the accused again tried to meet with the deceased parents, but was advised by the legal representative at the time it was not appropriate. We understand that it was inappropriate. But he's desperate to do it. And we respect Mr. Steenkamp. He says the time will come, and that's how it will be. But that does not mean that the accused is desperate to reach out. He is. But we respect that. We say that the accused is currently studying a BSc Management with law degree through the London School of Economics, which is an online course. As previously experienced, when he goes back to prison, of course, that will stop because he has not access. There's no access to the computer or internet. He's tried that. We make the submission that the above factors we've already made, but make it again, further constitute substantial and compelling circumstances and also mitigation. Then we deal with the newly introduced aggravation. We say, first, the Supreme Court of Appeal found that the accused had not acted negligently, but with dolus eventualis by discharging 4 shots he had foreseen, and that he had foreseen the possibility of the death of the person in the toilet, and that he had reconciled himself with that consequence. The SCA found that his incorrect appreciation as to who was in the cubicle was not determinative of whether he had the requisite criminal intent, and that he had gambled with the life of the person in the toilet who had nowhere to go. That's aggravation. We respectfully submit, however, that the trial court had to a very large extent already considered the above aggravation, as will be demonstrated above. And we first go to the conviction. In convicting the accused, the trial court found we are clearly dealing with error in persona, in that the blow was meant for the person behind the toilet door, who the accused believed was an intruder. The blow struck and killed the person behind the door. The fact that the person behind the door turned out to be the deceased and not an intruder is irrelevant. So that was already considered by the court. So it's not new aggravation. That exact fact was considered by this court. In sentencing, the accused, the trial court found that his negligence was gross negligence that bordered on dolus eventualis. mathematical calculations. Border 1 degree up, 1 degree down, I don't know, my lady. But it's not that this court approached this matter to say, well, this is so removed from dolus eventualis. The court's finding. The court said, you were grossly negligent to the extent that I agree with the state that your conduct bordered on dolus eventualis. We say the court found, the trial court, that he had used a lethal weapon. That's not new. And fired not 1, but 4 shots. Same finding. The court found that. 3, the court found the toilet was a small cubicle and there was no room for escape for the person behind the door. It's there. It's nothing new. 4, the accused had been trained in the use of the handling of firearms. All those factors had been taken into account at a time in aggravation. We say that the difference between the 2 findings for purposes of sentence seems to be that the trial court regarded the conduct of the accused to have bordered on dolus eventualis, and the Supreme Court of Appeal found it to be dolus eventualis. Secondly, the Supreme Court of Appeal found that although the accused may have been anxious and although frightened, it was inconceivable that a rational person could have believed with a heavy caliber firearm without taking even the most elementary precaution of firing a warning shot. Therefore, the SCA found that the accused did not entertain an honest and genuine belief that he was acting lawfully when he discharged the shots. We respectfully submit that for purposes of sentence, the fact that the accused's belief was not rational and did not meet the criteria for putative private defence does not negate mitigation. We refer to the Ferreira case above again. We submit that the context within which the accused discharged the shots should be considered in view of the following. 1, the accused may have been anxious and was frightened. 2, it was 3 o'clock and dark. A window had been opened in the bathroom, or had opened in the bathroom. 3, the accused was vulnerable because of his disability. And we refer to Ferreira, where the court found that the threat she had feared increasingly pervaded her thinking. Similarly, the accused's vulnerability over a long period of time must have pervaded his thinking. This was also the effect of 4, the accused suffered from an anxiety disorder. 5, the accused had a fight as opposed to a flight response. 6, the accused believed that an intruder had entered the house. 7, the accused believed that the deceased was in the bedroom at the time of the shots. With that aggravation, they don't disappear. We furthermore submit that the above factors negate evil intent and motive. Paragraph 26. We do not submit that the above subjective and emotional factors excuse the accused on the merits for purposes of conviction, as it was found that his fear was not rational and therefore not genuine. However, we respectfully submit that his failure to apply a rational thought process does not negate his vulnerability. The pervasive consequence of his vulnerability and his anxiety disorder, which must be considered in the context that the events occurred at 3. My lady has submitted above and stated in Ferreira that we refer to, a court must, for purposes of sentence, look solely at what an accused believed, irrespective of whether that belief satisfied the requirements of criminal liability in relation to the conviction. He's convicted. As such, his failure to meet a rational test for purposes of a conviction does not negate the accused's reduced moral blameworthiness and the many, many mitigating factors. We respectfully submit, my lady, that the Court of Appeal findings, as we referred to above, should not be viewed in isolation, but must be considered in the context of his reduced moral blameworthiness, the undisturbed mitigating factors found by the trial court, and the further mitigating factors that arose after the sentence, to which we will refer here under. We say it is prudent to also refer to the evidence of Mr. Steenkamp. We understand this unbearable pain associated with the death of his daughter. We respectfully submit that Mr. Steenkamp's pain was compounded by being exposed to an incorrect case presented by the state that the accused had a direct intent to kill the deceased. Clearly, unfortunately, Mrs. Steenkamp's pain is exacerbated by the fact that the state scenario caused him to believe that it was an argument and that the accused had a direct intention to kill the deceased. The truth is that the objective evidence proved that this was not the case. The objective evidence overwhelmingly showed that it could not have been the deceased screaming. However, the accused will always be subjected to an incorrect version, which has been so widely disseminated by the press, notwithstanding the court's rejection of this incorrect version. The danger is that a court must be acutely aware, as the trial court was, that the accused may not be punished on account of Mrs. Steenkamp's belief. We say the additional factors now available for this court to consider in further mitigation, meaning those factors, my lady, which did not exist during the previous sentencing hearing. My lady, Professor Scholes was previously appointed by the court as an expert psychologist to report on the state of mind of the accused in terms of the Criminal Procedure Act. For the present hearing, Professor Scholes produced a second report, and we say it was a report of exemplary scientific rigor. The approach taken to his assessment of the accused relied on a most widely used international inventory of psychometric tests currently available. And if I may say, none, not a single one of those tests, were refuted by the state. Not one. The state did not say to him, Professor Scholes, you applied now test A. Not a single word. It was rather, you're biased. Now, my lady, this is a man with respect. That because he wished to come to court. It was a man that was appointed by the court who did not know the defense from a bar of soap, that was responsible for Exhibit QQQ. I had a relook at that report and I thought, I think that person can assist the court, not me, the court in sentencing, because that person had the privilege under secure circumstances and controlled circumstances and regulated circumstances to analyze the accused. And he spoke after 2 Oscars. And I thought, I wonder what the position is now. And we asked him, and he was not willing to become involved. He was concerned that it's a dual role that he's taking and he get clearance. And that was the evidence at the start of his evidence to say, we leave you alone. Do what you must do. Look at the person and give us a report back. We want no input in it. And this is the result. Absolutely scientific test. He explains every test in order to come to his findings. And he says every time, the result of that test accords with my clinical observation and with my corroboration. We deal with those tests. We say in paragraph 36.1, that was so important to me. It's my word that I use, but I know that's actually the correct concept, or the word, that the accused is not a malingerer, and that the accused accurately described his current psychological functioning and did not try and create an overly positive or negative impression. So it shows that he found honesty in the accused subjecting himself to the test, honesty in the outcome of the test. There was no process, he could not find any process that the accused tried to. That's why you have certain tests to catch them out if they do it. 2, he found that his post-traumatic stress disorder has worsened since the previous test in that regard conducted in 2014. 3, his finding is that his general feelings of vulnerability have worsened. 4, and then you can't say, of course, yeah, it's because of your own doing. It's because of your own doing. But what we're then doing, we're going back to, should we convict him or not? That's not the process in sentencing. In sentencing, you say, now as a consequence. What are the consequences of your misdeeds? What are those consequences on you? The fact that you cause does not mean that you're not suffering. You still suffer. It means that you get convicted because it's not an excuse, but you still suffer. We say, he finds in paragraph 4, in accordance with the test, that the accused is experiencing an extreme self-consciousness and anxiety about being ridiculed and or embarrassed with which feelings have been exacerbated due to him being vilified in the media and the public. 5, the accused does not have psychopathic tendencies. He's not a psychopath, and that's important. 6, his risk for future violence, serious physical harm, and imminent violence is low. And that will become applicable when you again must reconsider, and I'm so grateful I'm not the court, but when you must reconsider again rehabilitation, deterrence, and to some extent retribution. These factors will come back. We say that Professor Scholes testified that the results of this test, were supported by his clinical assessment and collateral information. Professor Scholes also deals with the criminogenic needs, it is the crime-producing factors, of the accused, and came to the conclusion that prior to the offence they were absent, but for one factor referred to hereunder. And there he was accused of being biased. If he was biased, why would he keep in his file and refer to the report of Bai? But Bai's report, and I will take you there. Bai's report, if you read it in any context, it says in the beginning period, he was aggressive, violent, he was unhappy. And then he calmed down. And then he calmed down. That's Bai's report. Not that he was a person that remained violent, whatever. That's not what she's saying. And I must say, in this context, insofar as Ms. Mashabana's evidence contributed, I was thinking of it last night. If I'm in pain and I want my Voltaren, and for reasons given by Ms. Mashabane, she doesn't want to give it to him because she needs a prescription, and forget about the fact that you don't need a prescription Voltaren. I think I might have kicked the table over and said, I want my Voltaren. Yeah, he slammed the table with his notebook. What does that make him? It's a man in pain. She's doing what she believes is right. He's insisting to get his medication, what he believes should be available to him. Where does it take us? Does it make him now? I don't know. I don't think it really contributes. I think it rather shows more control than I would have expected. If I may just read the Bai report I've handed up to you, I think it was SA1. It says participation in prison, that's that part. Centre management reports that Mr. Pistorius struggled to adapt during his first month of incarceration as he was aggressive and verbally violent towards officials. However, at the time of the report, he was calm, cooperative, and adapted to the centre. That's the truth. So how factors that he thought was important. He did not want to criticize. He says, well, if you force me, let me show you difficulties in his report, but it's neither here nor there. We say that Professor Scholes, as paragraph 38, he distinguishes between the static factors, those that you cannot change, such as prior record of family criminality, and then dynamic factors refer to those factors that can be changed. And he says, in order to understand the risk of reoffending, one should focus on the dynamic factors, as the static factors are absent in the case of the accused. And he explained, my Lord, in his evidence that the only dynamic factor which was present in the accused prior to the offence was his values and beliefs regarding to the possession and use of firearms. And he says that's gone. The man does not want to touch a firearm, he does not want a firearm, and in fact when he in a traumatized way. So that factor is also gone. And that's important because that deals with your risk of reoffending. We say that Professor Scholes came to the conclusion that the criminogenic needs of the accused have been successfully addressed. Page 28, paragraph 41. And would the court give me an indication as to the tea adjournment?
What's your time?
11:15 now.
Is it 11:15?
It's 11:15. You would see I would most certainly finish by
You take out
and not too long.
15.
Thank you, ladies and gentlemen.
Right now, Defence Counsel Barry Roux has told the High Court in Pretoria that it should deviate from the minimum sentence of 15 years imprisonment for convicted murderer Oscar Pistorius. Now, arguments that Roux has given us we will be sharing with you in a little while. Do too.
How does this extreme heat affect basic conditions of living?
Food spoils more readily, and the risk of food poisoning outbreaks or food poisoning in a household.
Should we experience another heat wave soon, and it's coming?
First sign is always thirst. Thirst is a sign that already your body started to be dehydrated, and that's a very early sign that most people will be able to sort of pay attention to and then act on. That doesn't warrant any serious medical attention. But the minute that you start to feel slightly nauseous, that you start to feel dizzy, that's a sign that you need to stop what you're doing, get out of the sun, get into a cool area, slow down your intensity, get hydrated, cool down.
Join Dr. Sello Mutawung every Saturday from 9 till 10 in the morning.
So welcome you back. You're watching Newsroom. My name is Kendall Makhamat, and we've been busy with the sentencing process for Oscar Pistorius for his murder conviction. Renee, it's been a very interesting morning so far. I don't know what your take on the matters has been.
Well, I think it's not what I think, Kendall. Of course, let's ask our law expert here with us today, Alton Hart. What do you make of what we've seen in court so far this morning? I mean, it's been a very long day in court.
Yeah, like I said, if you look at it, what the two lawyers are busy with, I would be a picture to the judge and trying to sell that picture, saying my picture is the best. And that's how I see what's going down in court, because Barry's trying to make sure that Oscar doesn't get the minimum of 15 years, and Harry will obviously push for the 15-year sentence. So they are going to now finish their paintings soon, because Barry's now busy with his closing arguments, and I think Harry will now, shortly after that, come on and tell the court why he thinks that the court should reject the plea, if one can put it that way, that Barry Roux has put before court.
Now, there is this question of the 15-year minimum sentence. What factors are we looking at to determine the years that Oscar may get?
The thing is, this is normally, Barry's now going to try and put mitigating factors before the court so that the court can deviate from the 15-year a period that the court normally would give in instances like this. And the thing is, with this 15-year minimum sentence, discretionary sentence, the court may deviate if the court feels there's compelling circumstances by Barry Roux of the accused person, or the convicted person, if one should put it that way, of the convicted person that is placed before court, that the court should consider, and that the court feel it's justified to consider those circumstances, then he can deviate. But if the court feels that you've given me this and it's not good enough for me to deviate from.
Very interesting that you bring up the possibility that the court may deviate. A question on a lot of people's minds has been, why is Judge Masipa presiding over this sentencing process?
The thing is, Kendall, if one can go back, the thing is, the SCA has the powers to actually overturn a judgment that they're not happy with, and then they can also give a judgment or a sentence on that. But sometimes, because the court, the SCA, or the thing playing in front of them, because the trial court also made fact findings. And it's difficult for them to look at the record and try and interfere with the facts. And that's why the appeal courts would never interfere with fact findings of a trial court. And that's why they sent it back, because she had the opportunity to observe the demeanor of the accused, the demeanor of the witnesses when they testified, and then she can weigh up and say, but even so, after they've convicted him of murder on the count dolus eventualis, did he show remorse in the way he acted? Even the witnesses, did they try and paint a better picture of the accused than he really is? So that is the things that the trial court had privy and access to, where the Supreme Court of Appeal did not have access to those kind of things. What they got is most probably, I don't know if the judges was also like us onto our TV screens glued and follow some of the things, but if they had, they would have had some sort of insight, but normally I think they would not have been following because they might have thought this thing might come to us, X, Y, and Z reasons.
Very interesting that you bring that up. Earlier on, before we went back to court, I was trying to find out from you the pillars that PISTORIUS' defense lawyer is building his case in mitigation of sentence on. You started by talking about the moral blameworthiness,
yes.
Comparing Oscar's action to that of a pedophile violating a 3-year-old child. Can you take us a little bit through the moral blameworthiness as well as any other pillars that Beru is using?
Because the thing is like, and if people were following what's happening in court, they would see that Barry started off the process by going to the night of the incident and trying to say to the people, don't punish the gold medal winning athlete, the guy that was full of confidence, everybody around the world praised him, worshipped him, the ground that he walked on. Look at the guy on the night of 13 February 2013, I think it was 2013. Look at that guy. On his stumps, 1.5 meters, and Barry was now tapping into the emotions, I think, of the judge, of the broader public, and he started this journey there, saying, there was that guy. And even so, before he got convicted of dolus eventualis murder, the psychologist worked with him. And there the psychologist brought up, this is a broken man. So there already it shows that this guy was also affected by what happened. He might not have lost a family member, but he lost a girlfriend. And I think that attachment was not so long between the parties, but there was some sort of attachment, and we don't know how strong that attachment was because it was put in court about the Valentine's Day cards and those kind of things. So we don't know how strong that attachment was, but if it was a strong attachment, it could have affected him also very badly. If there was like little attachment, Gerry can come and argue, but there was little attachment and it didn't affect him that bad. So one still needs to see what's going to happen on Gerry when he shoots the stand, and then one can give a better rundown of what is happening currently in court.
And something I find a little bit interesting and has left a lot to question was earlier on in this trial, speculation on evidence being missed. Why was that not brought up to determine the sentence that Oscar may receive?
The thing is, like, once the state discloses its case, defense discloses its case, you cannot introduce new evidence. The only way that you can introduce new evidence, if the state asks the court, they must bring an application to reopen the state's case, to introduce new evidence that might be... I don't think that if the state has evidence that's new, that they feel is new, and it's not going to help their case, because they eventually now got what they wanted. They got a murder verdict against Oscar Pistorius. So I don't think, but if there was missing evidence, then those things were supposed to be dealt with in the trial or before the trial, and saying that there is evidence, we know that they exist, we want further and better particulars to that evidence. And if it's not given to the person, then there's nothing you can do after the trial has been concluded.
A little too late.
Yeah, very interesting stuff, and I do believe that we're going to be carrying on with the court case, and we're enjoying chatting to you, Elton. Thank you so much for staying with us the entire morning. We're going to take a short break, and we'll come back shortly. I think that...
We celebrate those who take strides doing good and changing the world.
I really think that education has to be revisited, and it's an integral part of teaching young people skills of the future.
There's always light at the end of the tunnel.
I think that the treatment should be made available, actually, because it's costly. Growth hormones are very, very costly.
Where there is a challenge, we bring hope.
I'm alive. And the brain tumor is gone.
Join your host Buleng Mulabati every Friday at 17:30 for more uplifting stories.
Now, we're going to be doing headlines for the news right now, and I believe it would have been Renee doing this, but she's standing by, and I think she might even do the sport for us, but we're not going to do that, Renee. I think I'll allow you to do your thing, and I'll do my thing, Renee.
Swapping our roles today, Kendall.
Yeah, absolutely.
Well, let's take a look at the news-making headlines. Pistorius sentencing proceedings must be completed today. Government is pulling all the stops to commemorate the 40th anniversary of the 1976 student uprising. Barack Obama has warned that the policy of Republican presidential presumptive nominee Donald Trump to bar This year marks the 40th anniversary of the Soweto uprisings. The theme for 2016 Youth Month is Youth Moving South Africa Forward. Now, Youth Month pays tribute to the school pupils who lost their lives during the 16th of June 1976 uprising in Soweto. On this very date, more than 15,000 students gathered at Orlando West Secondary School with the intention of participating in a peaceful march to the nearby Orlando Stadium. A day before the 40th commemoration, various stakeholders met at Orlando West, Uncle Tom's Hall in Soweto, and that was today, to reflect that fateful day.
On the 13th of June, NTOCC, we pledged that the demonstration should be peaceful. And the demonstration was indeed peaceful, because the students in Maurice Isaacson, after they have moved from one secondary school to the other, they moved over to Orlando West, and they were peaceful. No stone was thrown. The Naledi High School students, together with a lot of other secondary schools, they also came to Orlando West. Along the way, there was no violence. And my school in Skanontuana, for instance, together with my colleagues, Roni Matabate and the others, we moved from Skanontuana throughout to Orlando West. There was no single stone thrown. There was no building touched. The demonstration was peaceful. Now, the problem is that after the teaching, the burning that took place is the beer halls and the institutions like your rent offices, your bus offices. Those are the ones that were touched. No single school was touched. No single library was touched. No single clinic was touched. All we are saying is that this must not be done in our name. The June 16 Foundation currently has a program that we have to submit. Fortunately, he's here, Ndate Panyaza. We have to submit it to Ndate Panyaza. We will be going through a talk in the schools, one school after the other, in order to talk about this issue. Because that is not the culture of 1976. What we banned were institutions that resembled apartheid.
We knew very well that we are going to demonstrate, because we really did not want to be taught in that oppressive language, So as we went through the street of Soweto, at some point, I remember Tsieti told us that police are around. We must make sure we don't provoke the police, But now speaking to a crowd, It's something different. It goes in here and comes out the other way, but even so, we managed to be calm. So when we got to Orlando West High, already police were there, barricaded some of the street, and, we were told that other schools are on the way. We can just hang around waiting for those schools. We were excited, because while demonstrating, we never encountered any problems. So to us, it was like, oh, this is an achievement. So while waiting, and all of a sudden there was a shot. We just ran amok in confusion, running for cover. Something was itching our eyes, and we were told that this tear gas we can just pour. So scary and confusing.
On the day itself, on June 16, 1976, there was very little visible participation and action by teachers. The assumption is that teachers knew nothing about what was going to happen. In fact, that is to a large extent very true. The most information that went out from the student was contained in a 1-inch or 2-inch column in the then Daily Mail, which said the students were going to march and so on. But I and the principal at Maurice Isaacson were privy to a few who came into his office and asked him whether this was a wise move to undertake. And he said in Sepedi, le moya o foka ka takurele le siaming tsamang lo chisa thaga. That is, if the grass is dry and the wind is blowing in the right direction, go and bend the grass. Which meant if your assessment is that it is a good action, go and execute the action.
I think June 16 should be commemorated through concrete communication of concrete achievements. How far we have come and what are the greatest achievements, and concretely to say, I articulated quite a couple of them. Every year we must show our people the progress we have. It's a positive message we must give to our people, whilst acknowledging the challenges that still lie ahead.
Water and Sanitation Minister Nomvula Mokonyane officially opened the refurbished Kroonstad wastewater treatment plant in Moqaka municipality in the Free State. The area has been hard hit by the current drought, which resulted in water shortages.
We're here because as government, our commitment is to make sure that we've got sufficient good quality water, and we give the necessary support to our municipalities. We have a water works plant that we've just opened here that has been done within one financial year with an investment of almost 30 million, which would then help in terms of improving water availability for the Moqaka municipality, and complementing that with the refurbishment of our reservoirs would also contribute in improving the water quality of Moqaka here in the Free State.
I understand that this water treatment plant over here has been refurbished. What is the purpose of this plant?
The purpose of any plant is to take wastewater and convert it into usable water that can then be utilized for various purposes, and this amongst contribution towards irrigation in the area, but as well as for domestic use. What is of importance is that in the midst of the drought and water scarcity, we know that Moqaka was amongst those that have been hardest hit. So with the work that has been done, the refurbishment of the reservoirs, the completion of this particular plant, as well as additional tanks, the 80,000 what we really are trying to do is to improve access and reliability of water for these communities.
We also understand that this specific town has been like facing lots of problems in terms of water. How severe is this water problem in this region?
4 of the 5 dams that this area is dependent on, and the remaining 1 has got water that can only last for the coming 10 days. Precisely because of the plans and the interventions that we have put in place, we will be now releasing water through abstraction and using the boreholes in the area, as well as moving water from Velcom through our water tankers, and together. What bothers me with all the good efforts that we have done is a vandalism that is happening in our communities. Our people must not assume that the JoJo tanks and the containers that we are putting belong to government. They belong to them. Communities must protect them because we are told that they get vandalized and get sold to scrapyards. We need to save water. We need to conserve water. We need to now invest on. That's where we are now, because historically, use of groundwater, we have been over dependent on surface water, and with the beginning to adapt, we are reusing, we are conserving, but most importantly, we are also beginning to improve the storage capacity as well as the availability of water sources like we have here.
Minister, another problem is the region in Senegal and in Kwakwa. Like if you go there, the situation is just more severe than this one over here. And I've noticed that you went around sending water tankers to this specific area. Are you planning to roll that out to other severe stricken areas in the Free State?
Not only in the Free State, we have 8 provinces in South Africa that are affected, that have been declared disaster areas. And of course, we work on the basis of the plans and through the Department of Cooperative Governance in this province, a center that deals with these issues, so including in Senegal. And what we then do, we assess on the basis of water usage and water consumption on what else can we actually do, but we also add on with improving the capacity of the municipality, because you can bring 2 million water tankers, but if you don't have capable men and women to look after the infrastructure, to plan properly, to maintain our infrastructure, you will not actually succeed. And yes, I think the Free State is turning the tide in managing the disaster, as we have seen with other provinces such as in KwaZulu-Natal.
Now we'll be taking a short break, or rather, let's go back to the Oscar Pistorius court case.
Argument where Professor Scholes deals with or dealt with this evidence with desistance. Now that's important. We raise this because ultimately, when you look at the so-called principles to be applied to sentence, such as deterrence, rehabilitation, and retribution, it is important to look at the risk of reoffending. It's also important to look at the risk of offending. And this is what this paragraph is all about. We say that Professor Scholes dealt with desistance. He describes a desister as opposed to a persister as someone believing that he or she has the ability to the conclusion that the characteristics of for desisters resemblance of the accused's views on his criminal act, meaning wanting to make good. Professor Scholes come to the conclusion that the accused suffers from major depressive disorder with anxious distress, suffers from post-traumatic stress disorder, and we need to understand post-traumatic stress disorder. Post-traumatic stress disorder does not mean I am anxious because of the sentence. It means because of the events I suffer from a post-traumatic stress. It is absolutely to his fate after the events. The post-traumatic stress order. That he has elevated levels of anxiety, including symptoms and signs of social phobia, agoraphobia, and panic disorder. Professor Scholes is of the view that the mental health of the accused has 14, apart from a worsening of his clinical conditions, inter alia the PTSD, the depression, and the anxiety, the accused has become despondent and disinvested, leaving his future in the hands of God. In layman terms, he describes the accused as a broken, as broken, and in his opinion, he would hospitalize the accused if the accused was his patient. Professor Scholes also states that the accused has strong feelings of unworthiness and self-loathing. The accused has become isolated and fearful of venturing out in public. He has a feeling of disconnectedness. We say that the state tried to discredit Professor Scholes on the basis that he was biased and there's no substance. We say it's significant that the state did not challenge or seek to rebut the veracity of the test done and his clinical observations in that regard. He sought and obtained consent from the Health Council, that's the HPCSA, as he wanted to protect his objectivity. Professor Scholes explained that at the time of his report in 2014, he held the view that there were two Oscars. The one a superstar and tall, and the other a vulnerable, fearful, disabled person of less than 1.5 meters in height without his prosthesis. That was from a professor appointed by the court, not by a defense witness. And that was his report that was not challenged in this court. It was Exhibit QQQ. We all had the right to ask to cross-examine witnesses if we wanted to, and none of us exercised that right. Professor Scholes explained in this court that there is now a third Oscar, a broken man. Professor Scholes' evidence in this regard was supported by the evidence of Pastor Nell, which was not challenged by the state. Pastor Nell testified that he had visited the accused in jail, and I must say quite frequently, and that he observed him to be a broken man. Pastor Nell also testified that the accused was showing strong emotional feelings for the pain caused to the family of the deceased. Pastor Nell also testified that should the court so decide that the accused could be used for charity work in the church, which would entail sport and nutrition training and education for underprivileged children. Pastor Nell explained that the church is important. Whatever the court's going to do, it tells us something about the accused. That's the point. He wants to put back into the society, notwithstanding everything that has happened to him. He wants to put back. We say in further pursuance of community upliftment, the accused has also obtained employment as an external consultant at Twin City Development Pty Limited, and that's to manage the Early Childhood Development Project. And that copy is before the court's Exhibit A. You will see it. It's the first 1,000 days in a. And that's of course to do with underprivileged children and how to give assistance during that period. But the full document is before the court. It is evident from the above that the accused is desirous to contribute to social upliftment as advocated by restorative justice. In addition to the above, we submit with respect, my lady, that the following factors should be taken into account. He's already served 12 months, and we say that the impact of the 12 months imprisonment on him was harsher than 12 months spent in prison for another offender. We're not getting to a point to ask for privileged treatment. We're stating a cold fact. When you send someone to jail, for whatever the reasons, for whatever the sentence, fact is that a disabled person has a difficult time. You can say he's not exposed to a cell with many people in, but we know there's also the concept of segregation, where you're on your own and you sit on your own, you get up in the morning on your own, you go to bed on your own. You don't go to the dining room because you can't mix with the other guys because you're a risk. You eat in your cell. You do everything in your cell. You're not out. You get 1 hour a day out in a courtyard, a concrete courtyard. It's punishment. We understand it. And it's something that you must do. But it does not mean that it's easier for him. If you read anything on segregation, you would see that it's really something that could amount to torture, but we don't say that the department tortured him. That's not what we say. We understand because of his vulnerabilities, disability, because of his high profile, that they had no choice but to do that. That is so. There's no criticism. But factually, that's a consequence of his incarceration. That's what we said in paragraph 56.1, my lady. We talk about solitary confinement as that has been described as a form of torture. We refer you to the United Nations Human Rights Committee, what they say about it. We also refer to Professor Scholz's report, where he explained that psychological stresses such as isolation could be as clinically distressing as physical torture. But we say, my lady, despite the harsh impact of imprisonment components of his sentence with excellence, the rehabilitative programs that the accused completed were part of his sentence plan as a result of a comprehensive risk and needs assessment Department of Correctional Services. These programs and enhance the offender's social functioning, preparation for release and reintegration into the community. The programs the accused successfully completed are the following: New Beginnings Program, Restorative Justice Program, Crossroads Program, Anger In, Anger Out Pre-Release Program. Copies of the successful completion of the rehabilitative programs are annexed and marked. It's in the bundle to you. I think it's a waste of time to read it out to you, but you will see when you go to the conclusions every time that it was with excellence, that he motivated other people, that he was doing so well, and that you could see there was an eagerness to do well. That's the accused he wants to put back. He's done wrong and he wants to put back. We say in addition to the programs above, the accused also attended the following individual therapy sessions: his assertiveness, communications, conflict handling, relationships, problem solving, self-development and stigmatization. Insofar as any suggestion is that he does not accept responsibility for what he has done, you will see in the reports that before he was released that there's a column for that, and that the view was expressed that he indeed accepted responsibility for his deeds. That's not the accused saying, it was the department saying that. Therefore, on 5 June 2015, the Correctional Supervision Parole Board approved the accused for release under correctional supervision on 21 August 2015, being a date after serving 1/6 of the sentence. And I may say up to then, when you receive the sentence in terms of section 2761I, unless you do something wrong, you qualify and you were released after serving 1/6, which would have been a 5-year sentence, 10 months. Didn't happen in the accused place. In his situation, he was told, pack your bags, you're going home, sent all these things home, and then 2 days before there was a complaint, a petition, and the minister said that he did not take the petition into account, but coincidentally on the same date, he then decided that the provision must be looked at again, and a different interpretation was given, and he had to wait for the parole review board and then the parole board again, and he sat an extra 2 months. Now that has not happened to anyone else before, and the difficulty in understanding this, his release was well publicized by the media, long before the time, 6-8 weeks before the time. Why wait till the last 2 days to do it to a person? That in itself, when you know you're going out, you're sitting there in segregation, you're sitting in a place where you want to get out, you want to do your correctional supervision, and just at the last minute, so to speak, to say, you're going nowhere. You've sent your things home. I know we told you can go. I know the parole board found that you could go, that you qualified. You're staying. You're the first one that's going to be considered to apply a new interpretation. Whether that interpretation is right or wrong is not the question. It is the unfortunate timing of that. It was a long time before that you could look at that. When his release was published 6 weeks before the time, why not look at it then and say, wait, before you get excited, before we tell you to go out, we want to reconsider. You're the first one, you're the guinea pig, you're the first one, we're going to reconsider it. Not in this case, 2 days before. We say that the accused has almost spent 4 months under correctional supervision at the time of the SCA judgment. Thereafter, from December 2015, as part of stringent bail conditions, he agreed to submit himself to even more stringent conditions than the correctional supervision conditions. During this time, he was subjected to countless false alarms. I remember he sent us every time, said, there's a photo, I'm sitting in my house, the alarm went off, I'm not there. there's a problem with that alarm, but it's happened, and it caused him a lot of stress. We say that the decision to broadcast his trial live, it had, of course, its benefits, but let's look at the accused. How did it benefit him? And the resultant media frenzy it has created. It resulted in a trial by public opinion that will continue to haunt the accused long after the conclusion of this criminal process. No other accused has ever had to endure this level of publicity, misinformation and character assassination premised on a version that he had direct intent to kill the deceased, notwithstanding the fact that that version was correctly rejected by the trial court. Despite the fact that the finding remains that the accused did not want to kill the deceased, or did not even foresee the possibility of her, the deceased, death, as opposed to that of a perceived intruder, the accused case is still portrayed in the public domain as an example of gender-based violence. And that hurts him, because he was a person opposed to gender violence his whole life. And now suddenly when there's gender violence and you open a newspaper, his face is there. You see representatives standing for a fight against gender violence. They attend his trial as if he wanted to kill the deceased, as if he had direct. Nowhere along the line would you draw the line and say, enough. This man in his mind had no gender violence intent. It had nothing to do with, it's the same, I drive in my car, I make an accident, happen to be a child or a woman in the other car. How's that gender violence? It's not the consequence, it's the intent. He did not even enter his mind. On the contrary, it was excluded in his mind. He thought she was in the bedroom. Now he's become the face of gender violence. And it's fine to say, protect yourself, don't look. Don't look. It's not possible. It's not possible in this age and era to miss the media. It is not possible to say, I'm never going to open the internet and see my face. I'm never going to open a newspaper. I'm never going to look at placards. I'm never going to watch TV. Constantly it reappears. You see gender violence, domestic violence, you see Oscar Pistorius. We had, not too long ago, threatened with an interdict to stop a TV channel, to say, how can you do it? How can you use his face? This case has nothing to do with gender violence. But the penny doesn't drop, because some people don't want the penny to drop. It's not what they want. Ignore the court's finding, that's fine. Criticize the court, that's fine. Criticize him, that's fine. We want our perceptions. We say, my lady, that as a result of this sustained campaign of misinformation, the accused's reputation will never recover. And uninformed members of the public, or people who wish to remain uninformed in order to give preference to their own perceptions, have subjected the accused to public abuse and harassment. I told you about the incident. I mean, how silly is it not? He walks in a grocery store and he then gets, women start to scream, she's with a murderer in the shop. I mean, it tells me another woman came to him and said, just excuse her. I apologize for her conduct. But he's subjected to it. He cannot avoid it. We say, my lady, that these factors, in addition to what we've said, also constitute mitigation, but also should be taken into account in relation to compelling circumstances. Now, my lady, when I deal, and this is, in my view, the most important paragraph, is from paragraph 70. It's the reconciled facts between the findings of the trial court and the findings of the Supreme Court of Appeal. If I may fast forward, I'm coming back to it and ask you to go to page 38. Then you will see we deal with the appropriate sentence. And one thing we cannot do is to tell you what a sentence is. We just deal with the principles and then leave it in the hands of the court, what we should do. But, my lady, it is so important that when I deal with this reconciled facts, that we see what we must see. I was right in the beginning when I started to address you, I said there were 4 enemies. And it's that perception. This strong, world-class athlete shooting his girlfriend. And it's time, my lady. It's time for many reasons. For you would have known, you would have seen. But it's time to explain our address to you, to see what we should see. And for that reason, as Mrs. Steenkamp wanted photos, for that reason I want the accused to stand there, and when I address you on that, on his stumps, that we can have an idea of who the second Oscar was. Otherwise, it does not help. He would not be seen with that. So I ask permission that he could just come around, my lady, stand there when I point out certain things, that we have reality in this. And it's so important for our case and whatever may follow in this case, my lady. So I ask the court's permission. Thank you. And I'm told he's very embarrassed, but he understands that it's important to do that. He's very, very embarrassed and ashamed, but it's time. You could just take off the legs then. If you can maybe just stand on my side where I can see him and then talk to him. Lady, we talk about the findings and great respect for the Appeal Court of Appeal's finding. I absolutely respect it, but we're dealing with sentence. We have to see rationality now in the context of sentence. And what we have, and these facts can be tested. Just hold on to them. These are the distilled facts that can be tested. Let's look at who is the person. After incorporating the Supreme Court of Appeals finding that you must sentence today, or Friday, or whatever day, this is the person. It's 3 o'clock in the morning. It's dark. He's on his stumps. That's all common cause. Not on his legs. He's not running around the track. He suffers from an anxiety disorder. We know that the uncontested evidence was that when he was on his stumps, his balance was seriously compromised. And without anything, he would not be able to defend himself. He was anxious. He was frightened. That finding is not gone. And he was suffering from an anxiety disorder. That's not gone. This must all be seen in a context of his disability and the pervasive effect of the disability on his subjective thinking. He proceeded to the entrance of the bathroom because of his excessive fight response and his inability to run away. My lady, all these facts are factual findings, not disturbed, and where the Supreme Court of Appeal made different findings, we included them here. He was armed with a heavy caliber firearm ready to fire. His perception that he and the deceased were in danger was fortified by the following. The open bathroom window, which explained the noise he had heard. So it's not that there was nothing. Of course there was. It's factual findings. The fact that there were ladders outside his house, as his house was being painted at the time, which would have facilitated access to the bathroom. He had heard the slamming of a door and subsequently saw that the toilet door was in fact closed. He believed that the person in the toilet was an intruder and that the deceased was at the time in the bedroom. He fired 4 shots into the toilet door with a downward trajectory, thereby not aiming at chest height. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational and therefore not genuine. And that's where I stop. When I look at him and I think, how rational can it be, my lady? And if he may go back. I see that it's stressful for him if he may go back. And that's the point, and that's the Ferreira's case where I'm at, my lady, where we get to this point. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational. For purpose of conviction, I accept that, my lady. I accept that. That's the Supreme Court's appeal finding. That's fine. It's on law principles. But what are we dealing with when we look at that rationality? We're dealing with a person that's not like me. It's not like her, it's not like her. It's a person where I don't want to overplay vulnerability. That's not what I want to do. I don't want to overplay disability, but the time has come that we must just look at different eyes, at least with unbiased eyes. It doesn't mean because he's vulnerable that he can do what he likes. That's not what we're saying. But we're saying we're entering the field of sentencing. Look at that man's conduct. Was his fear rational? No, it was found not to be rational. Meaning that he was entitled to shoot? No. That's why he's convicted of dolus eventualis. But, please, let's understand. Let's understand when you combine these factors, you can't look at each one in isolation. Put them in one box and see who's this man that you must sentence. It's not the man running with evil on 2 healthy legs, wanting to protect his girlfriend and running to the bathroom to kill. That's not what it was. It's a compromised person. That's all. We say, my lady, the last finding was, in discharging the shot, he foresaw that he could kill the person behind the door, whom he perceived to be an intruder, and he reconciled him with that consequence. He gambled with the life of the person in the cubicle. That's the finding. We accept that. But we say, just look at the he. Factually, his conduct and state of mind can be distinguished in relation to moral blameworthiness and in the case of dolus eventualis from the conduct of the person with an able body who was not vulnerable as a result of a severe disability, whose subjective thinking had not been pervaded by his vulnerability, who did not suffer from an anxiety disorder, who during daytime thought an intruder had entered his house, who did not have an excessive flight as opposed to a flight response, who did not believe that his loved one was at the time in the bedroom, and he did not see an open window after hearing a noise resembling that window. Added to the above is the fact that the accused is a broken man who has increased post-traumatic stress, depression, anxiety, and vulnerability. And we don't have to be psychologists to see it, my lady. We don't have to. I don't think, with great respect, that any person could walk up straight after that, going through this process, this judicial process, where you go, where you portray it in public constantly, where you constantly in the media, you go to jail, you come out, it goes to the Supreme Court of Appeal, you come back, you again become subjected to the same process. That's the man, my lady. And of course we can argue it's because of your own doing, but that's on conviction. Let's look at the person and let's see what the system has done to him. I was thinking, my lady, but I'll come back to it. I heard when Mr. Hewitt was in the Supreme Court of Appeal, it was made clear you cannot hide behind your fame. My lord, my lady, he desperately does not want to hide behind fame. He just wants to be treated as a normal, ordinary citizen, not a well-known figure. He does not want fame to make him qualify for something better. He just wants to be treated like someone unknown, someone who has done wrong and must be punished. My lady, when we get to an appropriate sentence in the circumstances, the fact is, and for good reason, that sentencing is preeminently a matter for the discretion of the trial court. We refer to the cases. And we say that makes sense, as it is this court that has not only considered the facts, but experienced the emotions of relevant parties, which are not properly captured in the transcript. You can read that transcript many times. You don't see what a trial court will see. I can read it. I don't see some of the things. You read a sentence, but you don't read the emotion in the sentence. And that is why the rule is so strong that it's for the court, the trial court, to say, because the court smells it, it sees it, observes it, feels it. It's there. And you form an opinion of who this person is, who's lying, why are they lying, and what emotions they're going through. You form an opinion of the tragic incident, the pain of the family. You all have that. And you put that all together in context. Paper cannot do that. Paper cannot capture that. You must experience, you must be part of that feeling. And we say that is why the rule of law is that sentencing is preeminently a matter for the discretion of the trial court. And it's, I've said it before, I'm so happy it's not me that must impose sentence, because it is so difficult. It is so difficult, but there are fortunately aids to assist, to say these are the rules, these are the factors. We submit, my lady, that the aggravating factors resulting from the finding of the SCA, that's paragraph 76, page 39, do not outweigh the reduced moral blameworthiness of the accused and the other mitigating factors. We've in fact pointed out that you have, as close as what can be to the letter, also consider those factors. It's not that you ignore those factors. We say that this honourable court should, as best as possible, endeavour to strike a balance between the new aggravating factors and the many, many mitigating factors. In so doing, the court should be mindful that in imposing the previous sentence, the trial court has to a large extent already considered the aggravating factors. The question this honourable court must decide is what sentence the court would have imposed on a finding of dolus eventualis. That's really the question. That finding must then be adjusted in the light of the accused's reduced moral blameworthiness in relation to the merits, the fact that the accused was in any event sentenced on the basis that his conduct bordered on dolus eventualis, the undisturbed mitigating factors in relation to the conviction, the undisturbed mitigating factors considered at the previous sentence, the new or subsequent mitigating factors available to this court. We're saying, considering an appropriate sentence, regard must be had to the fact that South Africa is a vibrant constitutional democracy with a progressive system of corrections. And we say that punishment must have a rational purpose. And we refer you to the Mate case, where it says that it makes it clear that punishment must be rational. It's not, we know previously the first choice, the second choice, the last choice was send the man to jail in general. And the courts came out subsequently and said, but that should not be an approach. You should not say the man must go to jail. First, look at all options. Find a rational purpose, and sometimes you cannot avoid imprisonment, but then you do it after considering the whole spectrum of the rationality of a sentence. I'm sorry about that, my lady. We say, consequently, our courts, in fashioning a sentence with a rational...
Mr. Roux, just hold on. Okay, you may proceed.
Thank you, my lady. We say in paragraph 81, page 41, my lady, consequently, our court, in fashioning a sentence with a rational purpose that is appropriate to the individual circumstances in the particular case, have shown a predilection for the variety of different sentencing options at their disposal, rather than simply resorting to the traditional approach to impose direct imprisonment as an obvious and first choice of sentence. We say that same sentiment is expressed in Grobler. We referred you to Grobler's case. We referred you to the Sanei case, where the court emphasized that a broad scope of sentencing options must be considered, from which the most appropriate option must be selected. The court in that matter also emphasized that a tendency in the past to regard direct imprisonment in serious cases as the first, last, and only option was not valid anymore in an enlightened society, and that a mental shift was necessary to regard direct imprisonment as a sentence of last resort. The court in Sanei referred with approval to Siebert. It's there, my lady, saying exactly what it's saying. Then there's a Shariva case where the court warned to say a convicted person should not be visited with punishment to the point of being broken. And it goes on to deal about restorative forms of justice and looking at the interest of the society, the victim, and the community. Page 43 at paragraph 85, we respectfully submit that it's clear that punishment is not meant to break the offender, but it's meant to punish the offender and to protect society by providing the opportunity for the offender to be rehabilitated. And we say this was well understood by the trial court. We refer to the sentencing judgment and the record, where the trial court correctly found that excessively severe punishment might break the accused, and that the result might be opposite of what punishment set out to do, which was ultimately to rehabilitate the accused. That one paragraph in the court's previous sentencing, it encapsulates the correct approach to sentence. In paragraph 86, the accused does not fall in the category of offenders who again ought to be removed from society. The accused had already successfully completed all the necessary courses set out as rehabilitative benchmarks by the Department of Correctional Services during his imprisonment. His rehabilitation should not be in dispute. There is no purpose served, and we're dealing just with one aspect, and ultimately the sentence is in the discretion of this court. There are many factors. We're only dealing with rehabilitation. And we say about that, there is no purpose served in rehabilitating one who has already been successfully rehabilitated. The accused would not have been released on correctional supervision if he posed a danger to society and was not rehabilitated. And it's in fact clear in the reports. The reports are before you, and you can see that. As his rehabilitation has been achieved, deterrence and retribution must be considered to deliberate whether any purpose will be served in that regard through incarceration. We say that the devastating consequences of his actions have clearly deterred the accused. It is clear from his evidence. His incarceration of 12 months served as further individual deterrence. The deterrence remained during his correctional supervision and stringent bail conditions. He cannot sensibly be deterred anymore, and deterrence has with respect reached a point of saturation. We say any general deterrent advantage has already been achieved. If a sentence is now imposed on the basis of further general deterrence, this will merely serve as a veil for retribution. And we refer in this regard to S.S. Ter Blanche, A Guide to Sentencing in South Africa, the second edition, where he very aptly deals with specifically this effect, and where it's clear that once deterrence has fulfilled its role, that it does not remain as a sentencing option in a particular case. We also respectfully refer to deterrence, that deterrence has already been achieved. Professor Scholes testified that the accused's risk for non-violent reoffending was found to be low. That's also relevant to rehabilitation. Sending the accused back to jail would only serve to break him and to satisfy the consideration of retribution. So we must see if retribution is so important in this case. Our courts, we say in paragraph 92 and page 45, have moved away from retribution as a primary purpose of sentence, making it clear that retribution should yield ground to aspects of prevention and correction. This also seems to be the approach by the Department of Correctional Services, which on a daily basis experiences the negative effects of imprisonment. There was a media statement in 2014, and I'm not going to read it, but what they say, it was the Minister Ndebele says, inter alia, across the world, retribution for imprisonment has not yielded the results of deterring crime. Since retribution is narrowly focused on moral reprobation or outrage against criminal conduct, it fails to adequately reform offending behaviour and to repair harm experienced by victims of crime. And it goes on, the full article is also available to you. At page 46, paragraph 93, we say that the shift from retribution to prevention and correction is also reflected in our case law. We refer you to the Matewane case, and we say that that's quite a long time ago that that shift has happened. In paragraph 94, we say that we respectfully submit that the public interest would be rationally served, in this case by considering a sentence that incorporates community service, where the accused gives back to the community whilst not being a burden on the state or taxpayer. This is also consistent with Ubuntu. We again refer to the Ubuntu principle. It's well known to the court. And we say ultimately, my lady, that we try to reconcile all the facts and all the principles applicable. And then the very difficult task would, of course, remain with this court to decide what's an appropriate sentence. I do not know. I simply do not know. It's for the court's consideration, but we have put before you what we believe are all the distilled facts, where we reconcile the facts of your findings with the findings of the Supreme Court of Appeal, to point out to you that we have not since moved to an evil-minded person wanting to kill his girlfriend. That's not the process. The shift is in fact very limited. Very, very limited. And it's for the court to decide how to approach that limited shift and what to do about it, taking into account this man has served a jail sentence. And then with that in mind, to impose an appropriate sentence. I don't know if there's anything else.
Thank you very much.
Thank you very much.
Yes, Mr.
Mr. Court, my lady. Lady, we have not had the privilege of seeing the heads before we drafted our heads or before we started arguing, but I will make 11 introductory remarks on Mr. Roos' argument and then deal with the heads that we have prepared. May I hand up a copy of our heads? But I will deal with the introductory remarks firstly. Thank you. My lady, as I said when we started, we have successfully appealed the judgment. I will attempt to deal with the findings of the Supreme Court of Appeal unemotionally. But, my lady, the SCA's order deals with a resentencing in terms of the comments made by the SCA in paragraph 3. I will attempt, my lady, to address relevant points. I will not address society. I will not address investigators that wrote the book. I will not address perceptions. I will not address perceptions in the media. Although I will consider dealing with some of the perceptions that Mr. Roos has mentioned. May I start, my lady? That I was rather perplexed when Mr. Roos, and I wrote these words down, when Mr. Roos argued about the lady in a shop that wasn't happy with Mr. Pistorius in the shop. Mr. Roos said the following. She called him a murderer. A murderer of what? Not who. A murderer of what? Someone that he thought was an intruder. As if, my lady, the mere fact that accused thought it was an intruder would detract from the seriousness of murder. A murderer of what, my lady? That what is Riva. That is a murderer of Riva. That's a fact. That's a finding of the SCA. My lady, one can never argue that because there's a finding that the accused thought or knew it wasn't Riva in the toilet cubicle or thought it was an intruder and he fired 4 shots, that's not so serious. That's a less serious murder. My lady, that can never be the argument. Point number 5, my lady. Mr. Roos argued that Mr. Steenkamp's pain was exacerbated, understanding that this may have been Doris Directus. My lady, I've been astonished by the argument diminishing the father's real grief. I've been astonished. My lady, we saw Mr. Steenkamp. We saw Mr. Steenkamp explaining how he tried to hurt himself just to experience the pain. We saw if we want to talk about a broken man, we saw a broken man in that sitting there giving evidence. That was Mr. Barry Steenkamp. My lady, if it had anything to do with a wrong understanding of the facts, there would have been anger towards the accused by Mr. Steenkamp. My lady, he testified. There was no anger. There was no hatred. It was just a broken father explaining to this court how he grieves for his daughter. It has nothing to do, my lady, with a wrong understanding of the facts. Nothing whatsoever. That's point number 5. Point number 6, my lady. There was argument about a case, vleisversagie. But, my lady, this court and the SCA rejected a defense of putative self-defense. That then puts the Versace matter to rest. It's not relevant, my lady. So, as both the courts rejected that version. Point number 7, my lady. We will deal with it in our heads. We anticipated most of the arguments. Mr. Roux argues the accused accepted the judgment now because it's the court judgment. Because it's the court judgment, what else can he do, was the argument. My lady, but that's very different from accepting my wrongdoing and reconciling myself with the findings of a court. By accepting a court's findings, I have to. The court now convicted me of murder, so I have to accept it. There was no other way out. We approached the Constitutional Court. They didn't help us. Now, before sentence, I just have to accept the court's judgment. My lady, then there was argument that the accused studies will stop in prison. There's just no basis for it. There are hundreds and more people that study in prison. But it's based on what? An argument by senior counsel that his studies will stop. My lady, there's no foundation for that. But, my lady, may I then indicate that if one has a look at the register that was handed in, my lady, that's a register I think it was SC. One would see, my lady, that the accused requested various things and was allowed various things. In the end, even a TV. He was allowed a TV. Why would he not be allowed a computer to study, my lady? That just cannot be made and cannot be taken into account by this court. Point number 9, my lady. Mr. Roux argued about Sister Mashabana's evidence, that he can well imagine if he had pain and they didn't want to give him medicine, that he may have acted as the accused did. What I wrote down is that he may have acted. My lady, I have a different argument. I don't expect of any man to enter a room where there are 3 female sisters sitting, banging a table, throwing things on the table, being aggressive. But, my lady, we have a convicted prisoner doing that, convicted of a violent crime. But that's not all, my lady. This isn't the incident in October 2014, December 2014. It's an incident on the 1st of March or something else. It was in February. It's 4 months into his incarceration. My lady, point number 10. You've heard the evidence, my lady, of Mr. Steenkamp. I've listened to Mr. Roux saying, it is now time to see. My lady, there's a request from a father saying, it is now time to see. Is it not time to see what this accused did to Reeva Steenkamp? I have a request by the family, my lady. Let us show the world what this accused did. It wasn't an intruder. My lady, you have seen the photographs. I sit with them in front of me. Mr. Roux wanted the court to see and the world to see. We now apply, my lady, to let the world see what this accused did with 4 black talon rounds through a door. What this accused did to her head, my lady. That is perhaps time that we also realize that, because, my lady, that would then put us in a position to see what was caused by this accused. My lady. I will then apply, my lady, when I've had a full discussion with the family, for the court to lift the ban on those photographs, as was requested by Mr. Steen. My lady, point number 11. There's reference to S versus Ferreira. I'm convinced, I've seen in the judgment, that the court will look at the facts. S versus Ferreira, my lady, dealing with an abused woman who killed a partner after years and years and years of abuse. That's not what we have in this instance. So, my lady, if I will come back to their heads, may I then deal with our heads of argument? Really, may I refer the court to page 3 of our heads, paragraph 5. We quote the order of the SCA there, my lady. Point number 3, the matter is referred back to the trial court to consider an appropriate sentence afresh in light of the comments made in this judgment. Then, my lady, we will deal with comments made. We deal in paragraph 7, my lady, with the court's finding of personal circumstances during the trial. There's one aspect that I agree. Those personal circumstances that the court found will not have changed significantly. One can find that on page 7 to 13 of the judgment. My lady, but what wasn't quoted? Perhaps page 12, line 25 to page 26, line 8 of this court's judgment, where this court said, there was ever a feeling of unease on my part as I listened to one witness after another, placing what I thought was an overemphasis on the accused's vulnerability. Yes, the accused is vulnerable, but he has excellent coping skills. Thanks to his mother, he rarely saw himself as disabled and, against odds, excelled as a top athlete, became respected worldwide, and even came to compete against able-bodied persons. For some reason, that picture remains obscured in the background. In my judgment, to get to the real picture, the approach would be, we would have to be able to balance the two. My lady, that was echoed, the court's judgment, in paragraph 11 of the SCA's judgment. I refer the court to paragraph 11 of the SCA's judgment. It's a long judgment. I'm not a long portion, but it says how he excelled as an athlete. So the point I want to make is this unease was echoed by the SCA. My lady, what is very important and significant is an aspect that we find perplexing. Dr. Scholes testified that the accused suffered from depression and anxiety. But, my lady, accused counsel put to Sister Mashabane that the accused hoarded medicine that they needed for that condition. It is submitted that the ineluctable inference, my lady, is that either the accused malingered or purposely did not want to get better, or it was a disingenuous version that was put to the witnesses. What was it, my lady? 28 tablets and 14. Isn't it just an indication of this accused attitude towards the truth? I have to explain everything away, but I cannot stick to the truth. We also know that the tablets were in its packaging. Just before, when she said that, Mr. Roos said, I'll take it up with you later. But it's on record. It's on record that the tablets were still in its packaging. Although Mr. Roos tried to stop it, he couldn't. Lady, there's another aspect that's as perplexing. Dr. Scholz viewed that the accused needed hospitalization. His condition was that severe. He reported it to the treating psychiatrist. The treating psychiatrist wasn't called to back that up. No steps have been taken to hospitalize the accused. My lady, this court can only make one inference, and that is that the treating psychiatrist did not agree that his condition was that severe. My lady, we get to Mr. Scholz's report later. But those are aspects that the court must take into account in reading his statement. My lady, at page 5, as far as the seriousness of the crime is concerned, my lady, although the accused was at the time convicted of culpable homicide, this court said, on his own version, the accused knew there was someone behind the door. In this instance, the evidence showed that he thought an intruder was behind the door. Using a lethal weapon, a loaded firearm, the accused fired not one, but 4 shots into the toilet door. My lady, what else can that be than very close? We've argued, my lady, because we couldn't argue differently. When the accused was convicted of culpable homicide, we said it borders on dolus eventualis. Our argument's now different, my lady. Our argument is just that paragraph. If one takes that paragraph, I know there's somebody in the bathroom, I fire 4 shots through that into the toilet door. Why is that not very close to dolus directus? So our argue is the accused's degree of culpability